Alex stole it as well.
With especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about something that is not true.
We will bring the jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy. The dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
As the agent for Peyton Ansley John Milton, you are indicating to me that you're quite familiar with Peyton Ansley John Milton, and that's basically you. Is that correct?
I am the agent authorized to represent Peyton Ansley John Milton, as written in all capital letters.
All right, and you understand for my purposes, though that language doesn't make any sense. So
No, I do not.
I understand. Okay, well, I'm telling you that. And so I am, until you disabuse me of the notion, I am inclined to believe that you are both the agent and the person. So, and it's in
I'm
all
not
caps.
a person. I am one of the people. Thank you.
Okay, thank you.
I'm not a person, I'm one of the people. I am the Recovery Addict. Welcome back to the Court of Public Opinion. Welcome back this lunch afternoon. After lunch afternoon, I guess we should say. Tumwater Troy, that was from your neck of the woods. Here in a little down home. The folks from around home. Good to have you here. Thanks for your gifted membership. Went to Fire Girl, handmade by Wendy. Congratulations. I do need like a whole bunch of these. The Lifesavers, this was nearly full the other day. I'm not saying I ate them all, but I might go through about this many here this afternoon. So I'll trade you. Thank you. I'll need some water. How's everybody's lunch? Anything we know of that will be interesting this afternoon? There are a couple things, a couple small cases. Thurston's active with the attorney that needs work. Hello. Have you ever seen an attorney hang their shingle? You've got to see this. First of all, first things first. Kim R., congratulations, first in chat. We're going to punish you accordingly. Here we go. Let's jump to Thurston.
Yes, Your Honor.
This attorney is looking for a job. How do I know?
Forced you to agree to this continuance?
No.
In this case, you're obligating yourself for certain conditions, and that is that you will not commit a future law violation and you will stay away from Lucky Eagle Casino and their properties, at least for that 1 year. Do you understand that you are binding yourself under those conditions?
Yes, Your Honor.
Okay.
If those conditions are met, the state will dismiss this case with prejudice. However, should the case come before court for a hearing, to make a finding of fact, the court will only review the police reports and make a finding of guilt or innocence. Do you understand that?
Yes, Your Honor.
Okay. I find that Mr. Raul Gonzalez Vasquez is entering this agreement knowingly, willingly, voluntarily, and intelligently. As such, I'll endorse this and then sign off on this. Mr. Vasquez, stay out of trouble and not go to Lucky Eagle. Then things should work out best for you.
Okay, thank you, Your Honor.
Yes, thank you. Now we're going to jump back and get our resolution for our SOV sit. Thank you, Josh, for finding the tail end of this one.
Oh, you too.
That's the man right there in the back of the room.
There we go.
Shakes hands with the prosecutor.
Is that it? We got one more. Oh, yeah, Walker.
Fist pumps the dude in the back.
24F00101 SM, State of Michigan versus Mallory Walker. Recalling that matter.
But here by special appearance.
You got two waivers.
Mm-hmm. What's your name?
After discussing this with my client, I believe it's going to make responsibility to the violation, and we'll address, obviously, what the court is going to do at that point.
Okay. All right, so Mr. Walker, you're here for a probation violation on what kind of domestic violence. Maximum penalty could be up to 93 days in jail. You have a right to have a full hearing as to whether or not you're in violation in the manner that probation claims. At that hearing, the burden of proving the violation will be on the prosecutor that to prove it by the preponderance of the evidence, meaning more likely than not that this matter was in violation for these reasons. So if you have a hearing and you're found guilty, or if you waive the hearing to plead guilty, that's when the penalty comes into place. So you understand that. Okay. Allegations of failure to report, failure to complete screens, and failure to complete the redeem program. So you wish to waive your right to a hearing and plead guilty. That's as of December 12th. Okay. Anybody force or threaten you to waive your right to a hearing? Anybody promise anything to you? And you're pleading guilty freely, voluntarily? Okay. All right. So it's true that you did not report, didn't complete screens as directed, and didn't finish the redeem program, but as far as up to December 12th. Is that correct? No explanation at this point. It's just, is it true?
Yes.
Okay. Did I find that sufficient basis? And I'll accept the plea, finding it is freely, understandably, voluntarily, accurately, knowingly made. Okay, what's the explanation?
The judge is going through the various issues. As noted in the first item for failure to report, Mr. Walker indicates he was on Zoom for these 2 days and not let in by Ms. Turner.
I would like to say, this is failure to report as directed 12/2/25. I was only aware of 12/18. I sat in Zoom on 12/18. I was not let in. I have had prior conversations with you, which happened on November the 19th. I came here with on peace and good faith, asking you, based on my misunderstanding. I said, is it okay if I've had problems with Ms. Turner? I called her, she did not return my phone calls, things of that sort. I stated this to you on the 19th with the utmost respect. I did, and I also forementioned to you that, with you being an erudite to this, things that are happening, I didn't want to be back in here now in these conditions. I explained to you that my redeem program was an issue for me, and if I should have a.
Can we pause for a second? Let me go forward and then have you talk a little bit more to the judge. Okay, Mr. Walker. I know you got a lot to say. I just want to get out.
Can let me do the job
more before you address the judge. That's okay. Okay. As it relates to the plea screen, judge, as noted on the report, he did screen, albeit
days later.
Because
which is not a sir. You gotta if you don't do it the same day, then that's
judge. What I would
doesn't matter. It's a different day.
No, he acknowledges that part of the issues that he has had has been almost exclusively related to his job. His job required his logistics job, trucking. It requires him to haul long hours over the road to and from long distances. Most of these instances, when he was called, he found himself hundreds of miles away from any testing location that he was familiar with. Now, obviously, if he had developed a different plan as far as how to address that, maybe that would have been something that could have been addressed in the past. He didn't have a plan, unfortunately, and because of that situation that he found himself in, he found himself a long distance from the testing facilities. Similarly, with these, the redeem program, he would also find himself, again, because of work, called out and missing sessions. The dispute here, I want to be clear about what the dispute was as far as the redeem program.
But they say what it is.
Because
in the letter, he didn't pay and he took himself out the program, hadn't paid since September 6th.
Let me address
I have proof that is not the truth.
So, Judge, this is what the issue was. He paid for 27 sessions. He has proof that he paid for 27 sessions. The problem is that every time he missed a session, they would take the payment and say, that was the money that you owe for that missed session. And now you owe an additional fee for the new session.
Well, that's their program fee.
I understand that. And I'm just saying.
That's what you got to pay. And I don't have nothing to do with that.
Walker then found himself in a dispute with the owner of the program regarding.
I did not dispute her regarding her program.
It wasn't necessarily a dispute. It was more so a misunderstanding, because I asked her, I said, you never explained this to me in the beginning. And I aforementioned this to you also on November the 19th. I said, I wouldn't have never even put myself in that position to be put in a jam had I known that was our policy and procedure, because it did not make sense.
Sure, all you had to do was just go. For whatever reason, you didn't, and you didn't pay the fee to go back.
No, the fee. She told me that she asked me to pay, before I came back. And I asked her a question and she never responded. And this was right before I actually had.
Yeah, a lot of people that don't respond to you.
So we have proof. I have proof that she never responded. And it was not, the thing about it is I'm not opposed to doing the redeem.
Since he missed the whole month of May and barely attended 3 groups per month the rest of the time he was here.
May I have a dialogue with Ms. Ware, telling her that I attended school and she accepted.
Okay, sir, I'm not trying to fight with these providers.
I didn't say that you were, and I'm not trying to fight with you. I understand your approach here, but I'm not going to just not say.
Yeah, I got hundreds of people every year, thousands really, on probation. I say a good 95% of them finish with no problem.
Okay.
Why do we have people like you that just can't make the things, arguing with the people about the fee?
That's not the case.
Well, you didn't make them.
That is not the case.
You just told me you trucking and you can't make drops and you can't make the classes.
When I first started this, I explained to you that I was in a hardship. This has put a weight.
Sir, I'm sorry about that.
Too.
Why didn't we just send you to jail then? And then you wouldn't have had to worry about completing anything. You've just been done.
Thing about it was, I'm not in the position to keep putting myself in an unfinancial stability. I'm not in that position. I'm by myself. So being that I didn't want to take that when you gave me these terms, I said this to you on the 19th. On the 19th of November, I stated to you, I said, Judge Johnson, I said, I was under the impression that based on Ms. Iverson, the talk that I had with Ms. Iverson, it was that I could be done with this in 26 weeks, but you said that was impossible. You said that could not happen. So that put me in another jam. I've never dropped 30, even though I have missed these screens. I've never dropped 30. Marijuana and alcohol is not conducive to my body. I'm a stage 4 cancer survivor. I cannot do this stuff. So all I know is to work. That's it. That's all. When I was doing my redeem programs, I had to go on Saturdays. That was the only day that I could go. They changed the time for me from 12 to 2 to 10 to 12. So now I have to reschedule things, and I'm at least 12 hours a day. I'm going on 12 hours a day to make some substantiated money to try to keep myself out the home.
So what is this that you want me to do?
Gotta get me some of that substantiated money.
Your lawyer's asking to put you back in these programs. I'm not going to do that. That's not working.
And we discussed that outside, Judge. And what I would say is that Mr. Walker is very willing to do a different program. Obviously, they won't let him in to redeem. If the court is willing to let him in, he's willing to do it. If the court is not willing to let him in, understanding that he bombed out of these programs, what I would say,
you would have to start all over.
The thing about it is, I would rather start all over and under promise and over deliver to you to show you that I can do it than to sit here and lie to you to your face when I watched you be empathetic for a lot of these people today. That's not my attitude. I don't need this on my record. This stuff will hinder me for the next 5 years plus of my life. I'm moving forward.
Diversion?
Yeah, it was on the funnel status.
You gotta be kidding me. You messed that up?
It wasn't intentional. It wasn't nothing that I did intentionally. I just would have to, my boss, I would have to sit down with him and say, hey, Saturdays I cannot come.
Well, why didn't you do that?
Well, we were on a mandatory schedule, and based on how he works, we're doing construction and snow. Based on how the snow works, we travel to places where we might get stuck. So this is, and I'm not aware like, okay, well, I have to use the bathroom this day, but I'm in a catch-22 situation. It's either don't make no money and not find financial stability, or do this. So I'm kind of balancing the two, but in turn, I make sure that whenever I miss, I talk to Ayden. Listen, I'm not trying to make anybody mad in the courts. So I have to literally figure out what I need to do. I communicate with this young lady all the time, but I'm willing to show you under promise and over deliver, and show you will not have a problem out of me ever.
I think, and then the question becomes, Judge, because he has less than 52 weeks of available probation, whether or not if he gets in a new program, whether he's going to be able to do multiple sessions.
I don't know.
I don't know the answer to that.
Because I asked could I be accredited of whatever they gave me based on what I have.
Sir, I don't know.
Okay, are you willing to allow me to find out?
This is what I'm gonna do.
And the only other point Judge I would make is the court is not one that would do that. He's working hard, he's working way too hard, in my opinion. He's not able, he's obviously having, because of the work, ignored his court responsibilities. He's losing a deferral status. I'd ask the court to consider, just letting him take the loss of the deferral, and the court's gonna do that instead of a jail sentence on top of it, given his work schedule.
Your Honor, I'm working too hard for jail. I ain't got time for that. That's not going to give me the financial stability that I
Your
need.
Honor, as we've sat here, I have perused the report from this incident as I was not the prosecutor on the case at the time. I see that the child abuse charge was dropped and that the defendant was allowed to plead to domestic violence with 76948.
Mm-hmm.
I'm looking at the photos of the injuries and I'm surprised that that was even reported to him. I don't see that there has been much change in the defendant's attitude from what I'm reading in the report until today, to where he did not continue to be a danger to future partners or individuals in his life. I do believe that he has lost or should lose the deferral status based on his violations. Regarding the continuation of probation and a possible jail sentence, I think it may be best for the courts to just give a short jail sentence as recommended to close this matter. However, I am hesitant to say that I think that's what the court should allow, because I do think the defendant has more to learn. And
I do too.
Allow the court's role with that.
If the court is going to impose a jail sentence, which of course if the court is going to do that, I know I just want to be clear, I spoke to his boss with him out in the hallway. His boss is asking that he be allowed to report in the first week of February because.
I get burned on that reporting too much now. I'm not doing that.
Well,
people just take kindness for weakness and don't come back. Okay, so I'm willing to do this. Since he don't want to go to jail, I think he has a lot to learn. I'm willing to extend probation for 11 months is all I can do at this point, with oversight fees and all terms and conditions. You will attend the HEAL program in lieu of Redeem. And HEAL is full, so you may not finish it. So if you don't finish it, the jail sentence on this is 90 days, credit for 1. And I will suspend 89 days. I didn't even do 93. I did 90. I'll suspend 89 if you're in compliance. If you mess one thing up, you're coming back for 89 days. Mark my word.
So I got to do the HEAL program?
Yes.
Well, you said I won't finish it.
I don't know if you will.
You don't have enough time, so you just, what this judge is saying, is what I hear, is you have to be fully compliant at minimum till you get to the end of this probation, whether that's complete or not.
Okay, so if I'm fully compliant, then I don't.
Sir, I'm not bargaining. I don't know no ifs. I don't work on ifs. I'm telling you what to do. Either that, or we just gonna do the jail sentence and be done with it. Don't ask me no more questions about if anything.
I think the question, and I have this question too, Judge.
You can ask the question. What is it?
If he goes once a week like the program normally works, and he gets to the end, and because there isn't 52 weeks left, is the court going to violate him? I think that's the question.
They probably, I don't know. I'm not a soothsayer as to what the probation department is going to say or do. Nor do I know what I would do. So he just got to take this or take the jail. And I'm in the hiatus. 7694A is gone. That's revoked.
Probation before it. You can either take the jail, be done, or you can try to do the program.
What are my terms of probation?
Everything you were supposed to do before. Everything. Instead of the heal or the redeem, you're going to do heal. You wanted to prove something. All right. That's the sentence of the court.
Or the bailiff on the back had
Okay.
me standing up right now. Ooh. Wow. So we got the conclusion. We got the conclusion we were waiting for. Oh my goodness. What a day. What a day. All right, Judge Simpson, let's see. Hang on. Who this? Judge Satterfield? Judge Satterfield, how you doing? What are we doing today?
Can you unmute yourself? Are you there?
Oh, it's a name change. That's not going to be super exciting. Congratulations, ma'am, on whatever name you choose. I'm guessing it's not Mary Louise Corinne Cordova. So, congratulations. I hope the new name suits you well. That's probably going to happen. Let's go back up to Simpson.
And then, so this judgment then gets entered. Okay, so where is she now?
Balance is 3,000. So I'm curious as to how the POC appointment went and if they've approved it and kind of how we're going from there.
Yep, I'm waiting to hear back from Emily. I have all the documents submitted to her, and she's supposed to reach out to Melissa today, hopefully. Okay. If not, probably Monday.
Okay, Your Honor.
Amy, do we have any, if she'll let you talk about it? We have somebody from the court liaison officer that may have information regarding your hawk. Do you mind if she shares it with us?
Oh, yeah, go ahead.
Good afternoon, Your Honor. I don't have much other than to confirm that she did have her appointment on the 6th, and yeah, she's going to be needing money documents.
Okay.
But no reason to think that it wouldn't get approved. That I don't have anything in your ones. Your Honor, would you maybe forbear ruling on the motion and maybe set it over for a week?
Okay, for a ruling. Okay. No, I'll adjourn the motion. All right, so we can at least hear. You got that?
Sounds good.
So I'll adjourn this to the 16th. January 16th, 2026 at 2 p.m.
Can I request a Zoom?
Can you request it?
Yeah.
Sure, and I can say no.
Okay.
No, I'm kidding. You'll have to submit the form and then we do individual consideration on that.
Okay, so if everything gets paid, I don't have to come to court for this.
I'd say yes, but I think that's where we ended up in this one though. Here's what I'm going to suggest that you be here because I don't think, maybe wrong, but I don't think even if everything goes through by the 16th that the check is going to be there.
Okay.
Right. You might have the commitment that it's going to be done, but it won't be done.
Okay.
Okay.
Okay. Sounds good.
All right. Thank you.
Thank you.
Gulfside Lakes versus Deanne Brown.
Jillian Ingan for plaintiff. While Mr. Brown is coming up, I think that there are funds in escrow. If we could figure out.
Yes, there are. There are $680. Yes, $680.
We're about to switch to Judge Webster when she goes live. She just started
Sorry,
a new live
I
stream.
interrupted you before you could say your name.
My name is Deon Brown.
Yep.
Hey, Deon.
Okay. And what's the claim in this case?
Not including what's paid into escrow, I have $1,401.25.
That's owing.
So
And then
out
what?
the 680, we're at like 800.
Lindsay Ross, member for 11
Less
months.
Less than, yeah.
1 year's member, been here for 2.5.
All right,
Makes
man.
you an
How you getting this
OG.
paid? I have it paid all by the 21st.
All right. Time flies when we can't leave.
You'll have everything paid by the 21st?
I make a $900 payment next week, and then the following week it will be the remaining balance.
It's a big payment.
I'm waiting on I took the money out of my 401k, so it doesn't.
Right, but you,
I
maybe my math's wrong, but if you make a $900 payment, when do you plan on making that?
It should come Wednesday, but I'm going to say Thursday, just in case it doesn't come.
Of this upcoming Thursday. But if she pays that, gives me almost $1,700 when I include his escrow,
Yeah, I think that should do.
and that would do it.
Balance.
Oh, well, okay.
Yeah.
Okay.
If Your Honor would mind releasing the escrow.
Yeah, what I'll do right now is I'll release he escrowed a plaintiff. Okay, and we're going to send your escrow out. And then I'll adjourn it out just 1 week to the 16th, 2026 at 2 p.m. Okay, so the idea here is you get that 900 in. I release the escrow here. You're actually going to have a slight bit of a credit on your account.
Okay.
And then I don't need to see you again. Not that I don't want to, but I don't need to see you again.
Sounds good.
Thank you.
Does that work?
Yep.
Okay.
We're going to jump to Burnett. Oops, that was the wrong button.
So I'm not sure if we're ready to proceed with the initial today. However, we are ready to proceed with the plea. Mr. Allen has agreed to plead in count 1, 25 CF 98, with count 2 being dismissed and read in. The parties are making a joint recommendation for a PSI to be ordered. The state will be capped at the recommendation of the PSI while the defense remains free to argue. I have a completed plea questionnaire form with me. May I approach?
Just wait 1 second. Mr. Vila, the other matter is a felony bail jump allegation. With that new charge, does the offer still exist?
Yes, Your Honor, the offer is still intact, and we can do with the initial at a later date since Mr. Fosky was unaware previously.
So is this not something that could be contemplated as being a part of this agreement? Do you need time, since Mr. Flisky has never had an opportunity to even review if this existed?
I would defer to the defense of how they want to proceed, but the offer is going to be to dismiss and read in that charge into this global agreement anyway.
So it makes absolutely no sense to waste some time and to set it for another initial. Why don't I just give time? I want Mr. Flisky, since you're just aware of it right now, I am going to print it off unless you have access to it. You have access to it.
Do not believe I have access to it, Your Honor. I don't believe like I said, I wasn't aware. I wasn't appointed to this case.
What I'm going to do is I'm going to print this off for you, Mr. Flisky. I'm going to allow you to read it quickly, and then I am going to have you briefly discuss with Mr. Vila the matter, because I want you to do your job and not have any chance of ineffectiveness, and then discuss with him the potential of having this, as he stated, as a little bit of possible dismissed and read in, and then talk to Mr. Allen, and then update me and let me know what we're doing here today.
Certainly, Your Honor.
You can come on up, and it'll be printed right there.
Just grab it off the hot
We are
printer.
adjourned briefly.
I do like this judge. She can be a little
I
bit
have
of
a Debbie. Is the Debbie for the Gerald Lindquist matter? I believe it would be related to a victim. Is that correct?
That is correct.
All right. We are not yet there, obviously, and it actually may be slightly delayed, but I just wanted to let you know that so you can be aware and just hang out, okay?
Just hang out.
Okay, thank you. Appreciate
Just chill.
it.
Thank you.
You're up next. You're on deck. Do warm up. Thanks, Debbie. Okay, Judge Webster is giving us the same view right now in her court, so nothing happening there. Let's wait for Judge Webster for a second while I look and see where else we can pop around to see what's happening in our small courts. Probably our last day of court hopping today. Here's one we haven't been to in a little bit.
Bond will be set at $25,000 cash surety.
Wexford County Jail.
With the following conditions: that peer is ordered to keep contact information current, not leave the state without permission, and to commit no new crimes. I'm going to change that $50,000 cash surety. Not to consume any alcohol, be subject to random testings, not to act in any threatening, intimidating, harassing behavior, not to purchase or possess any firearms or weapons. Next arraignment, please.
Next up, says the judge, Judge Wiggins. I wish we could find her again. I think it was Travis County, Texas. That's what we were looking at. Well, Judge Webster's not here. Let me go there. If somebody can remember who she is so I can find her, that would be great. Travis County, Texas Court. Let's try that again. Did not work. Travis County, Texas courts. Judge Sylvia Holmes. Okay, Ashwalk Sharp. Or is it Ashwalk's Harp? I'm not sure which one that is. Thank you for that. Judge Sylvia Holmes. I saved her, but she hasn't come up in my feed at all. Judge Sylvia Holmes. Let's see if she's
person at the jail, please state your name for the record.
Tristan Walker, Your Honor.
Not seeing her. What's the name of her channel, though?
This is case number 26-82-SM, the people of the state of Michigan versus Tristan Lee Walker. Sir, you met with Community Corrections today and gave them an email address and a telephone number. Is that information accurate?
Yes, Your Honor.
And do you not have a mailing address?
Not at the moment, Your Honor.
Did you have the opportunity to meet with somebody from the defender's office today?
Yes, Your Honor.
I have a complaint that alleges that on or about December 6, 2025, in the city of Cadillac of Wexford County, it is alleged in count number 1 that you committed the offense of aggravated assault. That is a misdemeanor punishable by up to 1 year in jail and or a fine of $1,000, and consecutive sentencing may be imposed if the assault happened in a place of confinement. Do you understand those charges and the potential penalties?
Yes, Your Honor.
Did you read and sign an advice of rights form there at the jail, talk about your rights to an attorney and your rights to a trial?
Yes, Your Honor.
Did you understand those rights?
Yes, Your Honor.
You do have the right to be represented by an attorney at all phases throughout this process, and if you could not afford one would be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
Request the appointment of an attorney, Your Honor.
All right, court will make a referral to the public defender's office for the appointment of an attorney, enter a not guilty plea, and set the matter for a pretrial. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Historically, counsel, I show back in 12, there was a larceny less than 200 as a juvenile. In 16, a retail fraud third. In 20, malicious destruction of property less than 200 and a disorderly drunk. In 20, a carrying concealed weapon. 22, a domestic. 22, a domestic. 22, a disturbing the peace. 23, a disorderly drunk and an attempt to resist and obstruct. In 25, there was a possession of a narcotic less than 25 grams. And there was a 4A case back in 17. I also show that he is on probation for that narcotics case until November of 27. The praxis does score him at a risk level 4 with reports one failed to appear in his past. Any comment regarding bond, Mr. Hartog?
Yes, Your Honor. To some degree, it's going to be a bit of academics. I believe he's not supposed to get out until February 14th, as far as why he's already in there. I won't go into any of the stuff about the underlying allegations. I'm sure the people know more about that than I do anyways. But what I will say is I would ask the court to set a relatively low money bond. I've advised him that my understanding of the current rules is since he's serving a sentence, he won't get credit for the time before his set release date. However, if he is still in there afterwards, I'd like to see him get credit. As far as the fact that he's still on probation for longer than this case would take to resolve, I'm sure I'd ask the court to factor that in as well. I don't know what the probation conditions are. Being narcotics, I'm sure they're testing him, one would presume. I don't know that for a fact, it's a bit of a presumption based on my experience in other cases. I would ask the court to set relatively modest amount of bond and relatively modest bond conditions. And again, I won't overly allocate about the underlying allegations. I believe that would be fair. I don't believe he's going anywhere. He's motivated to resolve the underlying, or excuse me, the probation he's on for multiple years to come. Thank you.
So what is he in jail for right now?
I apologize for not immediately recalling that.
Ms. Lawrence, do you know?
He pled to possession of cocaine on November 10th. It says he got sentenced to 180 days and we have 53 days credit at that point.
I can't find her channel anywhere. It might be Justice of the Peace, Travis.
Okay, but this case arose in December, so he must have been out.
It's a jail fight, Your Honor.
Oh, this is a jail fight. Okay.
Jail
Thank
fight. So you picked up a charge while you were serving it for a charge.
Okay. All right. So the defendant does continue to receive credit on this case while in jail. The court will set a bond at.
Sorry about that. Wrong button.
Mr. Walker, if you do post bond, you are to appear as ordered, keep your contact information current, not leave the state without permission, and to commit no new crimes. Also, that you are not to act in any threatening, intimidating, or harassing behavior, not to purchase or possess any firearms or weapons. Ms. Lawrence, is there a need for no contact in this case?
I would actually request the court not impose one. I do know that causes some problems within the jail.
All right, so the court will not enter a no contact order. Anything else, counsel?
No.
All right, next to Raymond.
Next.
Is this the emergency bond hearing that we're gonna have?
No, I should still have Zachary Anderson.
Okay.
Let's go to this one instead.
7B, interfering with a peace officer, being charged as a 90-day misdemeanor and or $500. So it's 3 counts. Did you get all that?
Yeah.
Okay. So are you Miss Wentworth?
Yes.
Okay. So I'm going to put you in a breakout room with counsel, assigned counsel. You'll discuss your case, and when you're done, you'll come back for the arraignment, okay?
Okay.
All right. Thank you so much.
Thank you.
Red, you're right.
Could you
That
go to
is quite a
room
name.
2, please, if you could be so kind? Thank you.
I just had one question.
Judge says
That was a previous failure to appear?
She's never been
arraigned. Okay,
underlying
perfect.
charges,
Yep.
and she failed to appear in July and August of 23. Okay?
Yeah, okay, so I didn't catch whether she had do you know what I'm saying, ever been in court before? So, okay.
No,
perfect.
no,
Thank
brand new, please.
First timer. Ladybug's mom, hello, how are you doing? We did miss the bond amount. I apologize. But
Name for the record?
Zachary Russell Anderson.
Hey, Zach.
This is case number 26-102SM, the people of the state of Michigan versus Zachary Russell Anderson. Mr. Anderson, you met with somebody from Community Corrections and gave them a mailing address, email address, and phone number. Is all that information accurate?
Yes, Your Honor.
Did you have the opportunity to meet with somebody from the defender's office today?
Yes, Your Honor.
I have a complaint that alleges that on or about January 8th, 2026 in South Branch Township of Wexford County, it is alleged in count number 1 that you committed the offense of domestic violence. That is a misdemeanor punishable by up to 93 days in jail and or a fine of $500. Additionally, consecutive sentencing may be applied if certain conditions are met. Do you understand those charges and the potential penalties?
Yes, Your Honor.
Did you read and sign an advice of rights form there at the jail, talk about your rights to an attorney and your rights to a trial?
Yes, Your Honor.
Did you understand those rights?
Yes, Your Honor.
You do have the right to be represented by an attorney at all phases throughout this process, and if you could not afford one will be appointed to represent you at public expense, but you may be required to pay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
I was going to use the public defender, Your Honor.
All right, the court will make a referral to the public defender's office for the appointment of an attorney, enter a not guilty plea on your behalf, and will set the matter for a pretrial. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Historically, counsel, I show in 2015 an operating with a controlled substance. In 13, there was a possession of marijuana with 7411 and also a possession of a switchblade with hideout. The praxis scores him at a risk level 4 with him self-reporting, 1 fail to appear. Any comment regarding bond, Mr. Martell?
Yes, Your Honor. I would ask the court to consider perhaps even a personal recognizance in the situation. I do know, as the court noted, he does have prior convictions, and I'm not trying to say that domestic allegations aren't serious, because of course they are. But I do believe that non-monetary bond conditions can overcome any concerns the court may have. It does sound like there wasn't too many failures to appear at a minimum. I know that he is motivated to get to see this case through. I'll phrase it that way at this point in the proceedings. He's advised me that he's willing to obey no contact orders, things of that nature. He does have children in the state of Michigan and other reasons to stay in the state of Michigan. He might not be from our immediate area, but the state of Michigan all the same. He's advised me that he will come to all court proceedings. And I don't want to make it sound less than it is, but it is a 93-day misdemeanor, and I ask the court to consider personal recognizance.
Thank you. Ms. Lawrence?
The victim in this case is the defendant's, doesn't actually state whether it's his girlfriend or his wife, but it is his partner. This was essentially an argument over a vape in which the defendant lunged at the victim and at some point was on top of her trying to get the vape back. At this point in time, the people were just requesting no contact order with the victim.
A smoking device? A vaping? What do they call those? What is the part that holds the juice? What does that do? Just a vape?
So, Mr. Anderson, the complaint lists an address in Calava, and I know you said a mailing address is in Marine City. Are you actually living in the Cadillac area?
I was staying at the residence where the incident happened. My grandparents were the ones that had the residence in Calava, and they sold that house, so my mailing address went with them.
So if I were to release you with a no contact order, where would you go?
606 Scott Street, Marine City.
Okay. And do you have the way to get back and forth for court appointments?
I have a car that is in my grandparents' name at the residence where all of this occurred. But yes, I do have a vehicle.
Do you currently have a license?
I do.
Mr. Anderson does not have any prior assaultive history in his past. So the court will release him on personal recognizance. So Mr. Anderson, I'm releasing you on a personal recognizance bond, which is your promise to come back to court. You are to appear as ordered, keep your contact information current, not leave the state without permission, and to commit no new crimes. I'm ordering that you not have any contact with Shelby Harbaugh. No contact means no contact of any kind, not by phone, text, email, social media, anybody acting on your behalf. I'm also ordering that you not purchase or possess any firearms or weapons and not to act in any threatening, intimidating, harassing behavior. If you are found to be in violation of your bond, you could be arrested without a warrant, brought back to jail, and have your bond revoked. Do you understand that?
Yes, Your Honor.
Ms. Lawrence, was there any allegations of alcohol or drug use?
The defendant did admit to officers that he had a couple shots that night, him and the victim both.
All right.
There was not a PBT done.
I'm also going to order that you not consume any alcohol and you'll be subject to random testing.
Okay, thank you, Your Honor.
Right. So at some point you'll be released today. You'll need to make your way over here to the courthouse, which is about 5 blocks from where you're at. Go to community corrections and get signed up for testing. All right.
Yes, Your Honor.
All right. Thank you.
All right. And with that, we're going to go check out something that happened in Kristen Simmons' courtroom. Thanks again once to Josh this morning. Hello, everybody. Welcome.
Okay, on the record in the matter of this people of the state of Michigan versus Adrian Lamont Johnson, 25-03782. Appearance, please.
Good morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Good morning, Your Honor. Jacob Starks, the fourth Assistant Public Defender here on behalf of Adrian Johnson. He's standing to my right at counsel table.
Thank you. Today was the date that we reset this, this was the originally set date actually for preliminary examination. However, the court did receive a formal request for a PA 53 violation on the 6th regarding unauthorized phone calls and video calls to the protected person, Randy Crawford, which technically the court did already arraign Mr. Johnson on. So a court will enter a not guilty plea on those violations. My understanding is that there's been an investigator already assigned and that they're currently working on the discovery as it relates to that. The court did receive, however, and I think there were some emails between the prosecutor and the court administrator's office earlier this week in reference to a request for supplemental ADA accommodations for upcoming proceedings. Is Brandy Crawford Johnson present?
Yes, ma'am.
Okay. Ms. Johnson, you did file a request, and you can come and actually sit here for the purposes of if I need you to respond on this record in the in the witness box here. Okay, so the court received a request for ADA accommodations. This was after the court had advised you last week that you should get an attorney based on an affidavit and some statements that you made on this record that could implicate you for perjury and malicious prosecution claims, which are criminal actions.
Whoa.
So the court has requested that you seek counsel. And my understanding is that you were not eligible for the public defender's office, but you've not hired an attorney. Is that correct?
Yes, Your Honor, I did apply for the public defender's office. I also appealed when they denied me, and then they called me and told me that even though I pay my own rent and pay the rent for my son, who was a senior at Michigan State, and I only receive disability benefits from the Veteran Affairs Office, I think it was just barely, I didn't qualify. And I called probably about 15 different defense attorneys, and I couldn't afford any of them.
Okay, so with that being stated, you don't intend to hire an attorney, you intend to represent yourself or your own interest, even in the statements that you represented to the court?
Yes, Your Honor.
Okay, and you understand that there's a risk of putting yourself into a situation where you could be facing perjury charges?
Yes, Your Honor.
Okay. The court wants to also address your request for ADA accommodations, you said based on a panic PTSD symptom management. You're requesting permission to take breaks as needed if panic or disassociative symptoms escalate. By nature of how we run the court, if there's a situation where you need to take a break, the court always grants breaks. So that's not something that needs to be requested or specially implemented. You request ability to pause a testimony briefly for grounding before answering questions. I don't know what that means. Grounding?
Yeah, it just means that sometimes I have to calm down. I'm on Klonopin medication for PTSD.
Okay, we don't rush you, so that you don't need to request that. So you can breathe or take your time whenever you are getting ready to answer a question.
Okay, Your Honor.
Okay. Access to water at all times. Water is available.
For swimming.
Did you bring water?
For swimming.
No, I did not.
Okay, so how do you think you're gonna have access to all times? If you think I'm gonna get you the water?
AP Pfeiffer said I would have it.
We can get you what we give the jury. It's a very small bottle of water, but you're more than welcome to bring all the water that you need. If your ADA requires you to have access to water, I would have imagined you would have brought water with you.
That was just part of a request in case, you know, how
Got
long
it.
it takes.
We can get you water, but this is the size of the bottle. Okay?
This is a very
So
special
if you need
witness.
any more water than that, it's best that you bring a water bottle. That's why I have this one.
Do you need a special
Okay?
chair?
Permission to remain
Cushions?
seated. You will be seated at all times during your testimony and under oath. It says questions to be asked one at a time. For the
She
for
comes.
the
She
rules
comes
of
with her
evidence,
own writer.
they can't ask compound questions, so you don't need to make a request for that. Because they're not allowed to ask compound questions.
This is a witness.
If there was a compound question, there would be an objection probably by
This is a
somebody.
witness requirement.
No yelling, raised voices, or hostile or intimidating tone directed at me. I don't know what you mean.
What I mean by that, Your Honor, is I felt that AP Pfeiffer had that type of tone with me at the last conference. And my son had to watch on YouTube when the conference was over, where AP Pfeiffer called me crazy. And I have post-traumatic stress disorder, and that definitely put me over the edge. Your son had to watch, you said? No, my son, he watched it. He watched because he knows your hearings are on YouTube, and he watched it. And then I didn't want to watch it because I've already been in, you know, mental health crisis for a couple of months now. And I felt it was very unprofessional and against ADA law to
What does ADA law prohibits someone from yelling or raising their voice?
Calling someone crazy at that post-traumatic stress disorder.
I don't recall in my proceedings, Mr. Pfeiffer or anyone calling you crazy. That's number one. Number two, your requests you're saying these are ADA requests. Asking for no yelling, raised voices, hostile or intimidating tone in a courtroom. First of all, some of it's relative. And what's intimidating to one person is not what's intimidating to another. What is I could be considered yelling right now, but I have to be assertive and I got to make sure my voice carries. And I also give instruction to anybody who testifies here to make sure their voice carries. And I've heard Mr. Pfeiffer give curative instructions to people that I want you to speak like you're talking to the person way over there. And so you're not going to be able to control either of their tone or the volume of anyone's voice when they're asking you a question. That's not an ADA requirement. It's not protected under ADA either, okay? You're asking for court intervention if question becomes adversarial, aggressive, or re-traumatizing. I don't know what is traumatizing to you or re-traumatizing. The court will not put themselves in a position where they have to figure out what might be traumatizing you. My job is to make sure that they follow the court rules. If there's questions that are argumentative, that's against the court rules, or if there's an objection, then that's when the court will intervene by the nature of a violation of the court rules. But when it comes to just asking questions that you don't like, you still have to answer them. You understand that? Yeah. Ability to request clarification of questions, you absolutely can request. I usually give that instruction when I swear witnesses in. If you don't understand the question, just ask.
Did she file a motion?
And sometimes it could be that they just need to rephrase the way it was stated. Prohibition on threats of criminal exposure. Absolutely not. You must be advised that you could face, some criminal exposure by some of the things, especially under your circumstances. And never have I seen anyone so adamant that they want to produce documents to the court directly and on the record that could put them at risk for criminal exposure. And that's what we have here, which is why you were advised that you should get an attorney.
Yeah, Your Honor, the clerk was the one that told me that I have to serve that, right? So
the clerk cannot tell you that you need to serve anything. You probably call the clerk to find out how to get something to the judge. So that was on you. You can't blame it now on the clerk that you sent an affidavit admitting to perjury.
Okay, I don't believe I was admitting to perjury, but I understand.
Okay. And then let's see. You asked for acknowledgement on the record that I am a witness with PTSD. I don't know how you expect that to be acknowledged. You're only allowed to answer the questions that are asked. And so if that's asked of you, that's fine, to the extent that it may or may not be relevant to the information being brought forth. but but the court won't be making any acknowledgements that are on the record. And you're talking to me, and I already have been advised that you have PTSD. So
Yeah,
I'm the only one.
PTSD and panic disorder.
Yeah, so that's fine. You let the court know. I'm the only one making a decision in this matter. This is not a jury trial, so
you're an OG.
You don't need to make an acknowledgement to anyone other than me, and I've already been advised. Okay. Assurance that accommodations will not be used to assess credibility. That's not an ADA protection none of these things that you're talking about are ADA protections.
I was given the list
from who? Who gave you this list?
From one of the officials that I talked to.
What's the official's name?
I'm not sure. I don't have it with me right now.
Okay, these are not ADA requirements.
Okay.
These are some things that you might like, but in this particular situation, I'm the one that assesses credibility.
Okay.
No one else is assessing credibility, just me, okay? No negative inference drawn from emotional responses, pauses, or needs for breaks. I don't know what that means. If you're talking about how we determine credibility, there's a lot of mechanisms used to determine credibility. You won't be able to control that, okay?
I guess I should have rephrased that better. I just would ask Your Honor to take in consideration that I've been in an active mental health crisis for a few months now since my father passed away and everything else I'm dealing with.
I can imagine, and to the extent that you need, some pauses or that you need a break or that you're emotional, the court does not typically just make a negative inference of that, other than the fact that you are emotional. So let's see. Ability to submit brief written clarification if testimony is interrupted by symptoms. You are not allowed to submit written communication or clarification of testimony. Testimony is done here in court verbally and on the record. That's why I asked what official gave you this information, because we need to contact them, because this is not information that should be disseminated to people.
Your Honor, I'm a plaintiff in several civil cases right now, so the rules are a lot different. I've never been.
The rules are a lot different than what?
Where I can submit things, say things. So I'm just not familiar with the criminal court.
Did you know that I do civil matters as well?
No, I did not.
Yeah, we do civil and criminal here, so I'm very familiar with the civil.
Tell me about these rules.
That's why I'm asking you, what about this makes you think that this is appropriate, and even in civil court?
To have ADA accommodation?
These are not ADA accommodations.
Can you repeat the question? I'm sorry.
These are yours. I asked for the person who gave you this list because we need to ensure that this is not being disseminated for people to believe that these are reasonable requests. There's civil or criminal. Your testimony is on the record under oath, in person, not in writing.
Okay, I understand.
Scheduling and environment. Testimony scheduled earlier in the day when possible. The testimony will take place whenever the court's able to get it taken.
It was a list, I'm sorry. Those weren't all just my.
Limitation on the length of continuous testimony. We will not limit the testimony. You ask the questions. Sometimes cross-examines and direct examinations take longer than others. I have no control. I don't know what their questions are. I don't know anything about the evidence. And now we have a bond violation, so that could take even longer. I can't limit that. The only thing I can do is give you breaks as needed.
Thank you.
Let's see, quiet area away from the opposing parties. You're looking for a quiet area away from the defendant?
No, that was on the list.
Okay, permission to leave promptly after testimony concludes. So once you're finished with your testimony, I usually ask the attorneys if you're free to be excused. They'll let me know if you can be excused or not, okay? If you're not able to be excused, there may be a circumstance where we'll put you in a private room.
Thank you.
And then you're asking for confirmation that ADA accommodations will be implemented, and of course, to the extent that you needed ADA accommodations in the court, the hearing aid, ability to, get your mobile device in here. Some of those things, then we would make sure that happened. These things that I have here are not ADA accommodation or requests that are protected by ADA, I should say.
Okay.
Assurance that the requesting accommodations will not result in retaliation or prejudice. I'm the only one making the determination here. I'm taking the time to go through these one by one with you. So that you are clear, whoever gave you this list should have been clear that these are things that you can maybe request, but they're not protected under ADA.
That's right.
And then accommodations to be memorialized on the record, which we've done. And so did you have any questions about this?
No, I would just request that whenever, if you have time, to review the January 2nd conference where I was attending and where everyone had left the room. And it was just you and Assistant Attorney Pfeiffer in the courtroom. And that is where you could see it on YouTube where he called me crazy.
Okay, I will review whatever is that you're requesting me to review. Again, you're not looking to hire an attorney to represent you?
I tried to, and I just couldn't afford when I was denied public defender.
Okay, my other concern is that I believe there was some level of request that you are asking to retract something that's out of the court record. You don't have the ability to retract anything that you filed with the court.
Okay.
Okay, so that will be, whatever you filed with the court will remain as part of the court file.
I was just told that by Attorney Pfeiffer that no one could accept it except the detective, so the detective has it.
I'm not sure what you're referencing.
He said that he could not accept any affidavits or clarifications, and the defense attorney cannot, and the judge cannot. So he said that I have to submit it through Detective Kennedy.
Right, correct. So you can be in contact with Detective Kennedy. I don't know if she's here today or not. But that's your best bet, is to be in contact with her and provide her with any information.
I did.
Okay, very good. And so if you don't have any other questions, I'm going to let you go back down to sit, because I believe we need to address the timeline here for the exam, because I don't believe that the exam can go today because the detective is still working on the evidence, correct?
Yes, there's one other, again, nuts and bolts issue for the record. Because one of the emails from Ms. Crawford said that she was advised that she did not need an attorney. I just want to make a clear record that it wasn't the public defender's office who advised you of that, right? They didn't say you don't need an attorney, correct?
No.
Okay, perfect.
Who advised you that you did not need an attorney, man?
Pretty much every attorney that I called that was too expensive. They said that witnesses, you normally do not require an attorney unless there's a charge.
That's valid. That they would say that unless you told them about the affidavit you sent.
Yeah, I told them everything. They just said that they don't even accept clients unless they have a charge.
They don't accept clients unless they have a charge?
Unless there's a charge. Most of them didn't even know what a conflict attorney was when I asked them.
It must not be criminal attorneys.
They were.
It doesn't make sense. I have a criminal attorney sitting right there. Are you familiar with the conflict counsel?
Yes.
Because you are a conflict counsel often, aren't you?
Yes.
Can you represent me then? Because I've asked everybody.
No.
And so, yeah, I don't know if you've been calling criminal. The conflict counsel is quite common.
I have.
And then there's a lot of times where witnesses have to have an attorney to protect them from, saying something on the record or even questions that could, be self-incriminating. You understand your right against self-incrimination.
Yes, I tried. I called a lot of them, and most of them wanted $5,000 to $10,000 down just for 1 hour.
That sounds accurate.
Yeah.
For a retainer, but
I have a son that goes to Michigan State, and I have my own bills, so I have no way to afford it.
I can imagine. I recognize that you're strapped. But the court has done with the best that they can do. I can't make the public defender take the case.
Right.
And I can't make you get an attorney. That I can only give you an opportunity to do that, to protect yourself.
Okay.
So we're going to have to move forward with this case either way. Let me you could go have a seat though. Thank you, ma'am.
Wow. We might have to pop in for this one. What's the calendar look like, Judge?
Let's see. What do we know a timeline of when the detective could have this done?
I think 2 weeks would probably be the earliest. There's a good number of calls to go through.
Ma'am, you're raising your hand.
Yes, may I say something else about Detective Kennedy? I called the Lansing Police Department and did a FOIA request for the police records. There's 2 different police reports, and they both told me that both police reports are closed, and they'll be giving me the FOIA request today.
I'm sorry, what police report are you looking for?
There's a police report from the day that Adrian was arrested, and there was a police report where I spoke with Detective Kennedy, and both of those reports have been closed.
Wow, that's nice.
February 19th at 9:30.
February
19th at 9:30 work?
Your Honor, if I may just briefly just state for the record that Mr. Adrian Johnson is not stipulating to this request for adjournment, Your Honor. He is preserving his rights to have his examination within 21 days. And respectfully, if the people are unable to proceed today, Mr. Johnston would request a dismissal at this time. I just want to make sure that the record is very
Yeah, I
clear.
agree. I'm going to make the record very clear too, because we addressed this last week. The reason why we have to have a delay is because there's been allegations of possible witness tampering. And how many alleged phone calls?
It was a good number. I just don't have.
On a recorded line from the jail to the victim. So he doesn't have to stipulate because he has a bond violation from involving recorded calls. So the court's going to find good cause because I got to run all of this before I can run the exam. I got to address the bond issue.
Understood, Your Honor. Thank you.
You have your hand up, ma'am.
Yes, ma'am. I called the Eaton County Jail and talked to Deputy Weller. And I asked him if Adrian made any calls the morning of the conference. He said Adrian did not. And I asked him if he's made any calls to my phone number at all.
What do you want me to do with this information? Because this is called hearsay.
Okay,
and you're not even on the record. So what do you want me to do with them?
I just want you to know that he's never called my phone number.
I can't know it unless the person you talk to is subpoenaed in here under oath and questioned. That's the only way I can know.
I think he should be a witness. So.
Well, I don't pick the witnesses. Any other matters? For the record, the court's finding good cause to go beyond the 21 days.
Prosecutor,
no, Your Honor.
we
Nothing
don't
else
pick
for
the
the record.
witnesses either.
February 19th at 9:30 works for you, counsel?
Thank you, Your Honor. I certainly, with the matter being under investigation, I will abstain from any further arguments about bond at this time, but I will request an opportunity to respond upon the conclusion of the proceedings on the 19th. Your Honor.
Very good. Thank you. Bond will continue.
Thank you, Your Honor.
Thank you.
Who's got our calendar? And circle February 19th.
We have to reset Hebler, or is Hebler here?
He's downstairs. They brought him.
Okay, are we running that one?
No, Your Honor.
Okay, he can be brought up. And we need to reset Wade.
So for those who are wondering where this is, where they can find it,
Where has to find good cause on that one.
this is on Judge Kristen D. Simmons' channel, and it happened 3 hours ago today.
February 20th? Yeah.
February 19th is podcast Thursday. Yay, bonus. It's the podcast after Valentine's Day. Yeah, the lady getting up there saying, I'm sorry, I'm involved in many civil cases where I'm the plaintiff. There are different rules there. The judge is like, I do civil. Tell me about these rules that I don't know about. Oh, that was just classic. Josh, thank you very much. That was a great find. Thank you. And Josh has marked it on the calendar. Well, I'll talk with Mike as the last hearing with more context. Yeah, I'm sure there's a lot of backstory here. It's abuse allegations and a witness statement filed under oath, but then retracted or attempted to retract or changed or something. That's where the perjury comes in, where she needs a lawyer because she's going to have to plead the fifth on the stand. It's going to be Josh, you get an extra star, a superstar from Lindsay. Thank you. Wow, what a day to watch court. It's a great time to be alive, isn't it? When we get to see all these amazing things happening. And this is just all today, right? It's just current stuff that's happening. Let's see, Judge Sheila Johnson. Have we talked to her lately? Hello, ma'am. How are you doing? courtroom's a little sparse. Is that a defendant or a lawyer? Looks like a defendant from their posture. But you don't have anybody else. This is the essay courtroom. Yeah, she's busy, so we're going to bail. All right, let's see who else can go to. Judge, expedited accusations in Fulton County. That's nice. Burnett, we were just up there. Let's see if we can get over to Kansas real quick. Kansas or maybe Washington. Simpson still doing landlord-tenant. Oh, there we go. Preliminary hearing, Judge Webster.
She was the only one in the vehicle.
Yeah, but if you found it you found it on the passenger side.
Correct.
Okay, mistaken. But thank you. And the vehicle is registered to the correct vehicle. The plates were valid, correct?
As to my knowledge at the time, yes.
Have you changed your opinion of that?
No.
Okay. And how long have you been on the force, Officer Fisher?
I've been employed with the Greenwood County Sheriff's Office since December of 2019. I've been a commissioned road deputy since January of 2021.
Okay. Have you had any other employment besides the Greenwood County police employment? Have you worked for another police station prior to this?
No, not prior to this, no.
Okay. And can you explain to me how this pill bottle had written on it with permanent marker Amy's name?
It had a clear A clear M, and a partial Y that was on the pill bottle. It's been photographed and added.
Do you know why it was written on the pill bottle?
No clue.
Okay, fair enough. Don't want you to speculate. And during the time of your stop till Ms. Gum and you left, did AAA ever show up?
No.
How long of a occurrence was that? And I'm asking you to estimate.
To estimate?
Yeah.
From the time I received the dispatch to the time that she was taken into custody, or we left the scene?
Left the scene.
I'd say probably a good hour and a half.
Okay. And did someone else tow the vehicle besides AAA?
Yes, one of the tow companies that is contracted with the sheriff's office towed the vehicle.
And when you say sheriff's office, you mean Greenwood County Sheriff?
Correct.
Okay. Did you find anything else in your inventory log anything else illegal when you were making your search?
No.
Did you find any papers on these new dogs?
Again stated, sir, I never saw any paperwork that would indicate it was for employment, nor on these new puppies. That was of value to me.
Okay.
Hang on, we're doing dogs? I thought we were doing
Good.
traffic.
If I could just have a second.
Certainly.
I thought we were doing a traffic citation. Now we've got pets involved. Not sure how that happened.
Judge, may I have a second as well, please?
Yes.
Thank you.
You're welcome.
Deputy Blake's headed to the little officer's room. Now confirmed, perhaps a rumor. Let's move on until more info. Okay, interesting. It wouldn't surprise me. There's been moving and shaking in that direction for a while now. Client has some words to say there. Was this dog medicine, but really her drugs? Are we talking about is the dog Amy? Isn't there a song about Amy? Pretty sure there's a song about Amy somewhere. I think Britney Spears sings one, but that's not a good one. There's got to be another one. Amy, what you gonna do? I think I could stay with you. Once in love with Amy. Yeah, Winter Libby. That's the one that came to mind. But we don't want that one. Yeah. Isn't it Britney Spears? It sounds like a Britney Spears sort of song. It's almost like a choker she has on.
My client is of the opinion that you called off AAA and that's why they didn't show up. Is that correct? You're muted.
I apologize. No, not to my recollection. I ever called off AAA. She was complaining that they were taking forever and she was still trying to figure out how to get back. But I don't recall. I never talked to anybody with AAA. She was trying to make contact with them.
And she also tells me that not 4, not 5, but more than 6, 7 times, she offered to show you copies of her tax return, which provided that she was in a dog breeding business and she did have those in the car with her.
I don't
Is that
recall
correct?
that. I don't recall.
Don't recall. And that she also asked you if she could use her phone and her mother could send her a photo of her dog breeding license, which she also would have presented to you had you asked for it. Do you recall that?
I don't recall that at all.
Don't recall. Okay, Your Honor, I have no further questions.
Any redirect, Ms. Gillette?
I only have a few questions, and then I've pulled up the photos of the bottle so that you can see it. Deputy, did she tell you a specific breed of dog that she
must be a beagle
was breeding?
No, not to my recollection.
Do you remember anything from that night, Deputy?
Did you end up photographing that bottle and the pills?
I did.
Your Honor, did you take the photos yourself?
I did.
And are they true and accurate depictions of the bottle at the time that you seized it?
They were.
And was that vehicle free to leave or go anywhere on its own power without proof of insurance?
No.
Your Honor, permission to share screen the photos Deputy Fisher has taken. I have 4 of them pulled up. They will be labeled as states 3, and I will give you a number for each photo. It will be states 3, 4, and 5. Let me make sure I have 4 of them. Yes, and 6.
No objection.
Go ahead, proceed, please, Ms. Gillette.
All right. The first one that we are going to share is going to be 445.
455.
It's 4465.
4465. All right, so it is Exhibit 3, a photo with photo number 4465. Is that correct?
Something
that
ketamine.
Is correct, Your Honor.
Thank you.
Ketamine? I think it's fetamine. Is it?
It
Without objection, it is admitted.
shows that writing on the label.
Okay.
And the next photo that we will share is 4466. It's going to be the next photo. It's a very similar photo to the first one.
So it is states 4, photo number 4466.
That is correct, Your Honor.
Okay.
It's like the same picture.
Now that's the same bottle, just from a different angle, is it not?
tight,
It
slightly.
is, yes.
Slightly turned.
And the name would be up here, and I'm specifically not showing the name of the VF because we don't want to put any identifyings on there. The next photo that we are going to show,
I think the name would be
is
important.
4467. It'll be marked as States 5.
If the name is
And
like
we will
Lassie or
share
something.
it.
Oh, nice. Top-down view. 2 pills.
That's an inside view looking down at the same bottle.
Same bottle.
2 pills, and that's exhibit 5.
Deputy, is this the same bottle that you photographed the outside of?
Yes.
And are the 2 pills at the bottom the pills that you're talking about?
Yes.
That
And
was exhibit 5, Miss Gillette.
yes, and state 6 will be photo 4468.
Okay.
Deputy, are these the same pills that were inside the bottle?
Yes.
And the pills are marked with 50 milligrams?
Correct. And the bottle was marked at 40 milligrams.
And they're different colors, right?
And when we're done seeing this photo, Your Honor, I believe I can still pull back up photo 4466, and you will note in photo 4466, it is
Light
a
green,
40
yellow.
milligram prescription bottle.
Light green, yellow, oblong capsules. Light green
I
and
will
yellow.
pass this witness back to the defense.
Those 2 pills, those are the ones that were referenced in the KBI lab report in exhibit 1 as was dexamphetamine. Dimethylate. That is quite a mouthful on that medication. All right.
What is that for?
The exhibits will be admitted 1 through 6 if they're not already. I think they all have been except for 3, 4, 5, and 6, and they are now admitted if there's no objection.
No objection, Judge.
All right, admitted. Anything further, Ms. Gillette?
I do not believe so. I'll pass this witness back to the defense.
Recross, Mr. Wiggle?
Deputy Fisher, having now looked at State's Exhibit number 6, it's your testimony that there were 2 pills in that bottle and not just 1, correct?
Correct.
That's all I have, Judge. Thank you.
Okay, thank you. All right, Ms. Gillette, you may call your next witness.
The state will, Your Honor.
All right, is any evidence? I'm sorry, Ms. Gillette?
Deputy Hanson's for the next case.
Oh, okay. Mr. Wagle, any evidence for the defense for preliminary hearing?
Not for purposes of this hearing, Your Honor. Thank you.
You're welcome. I do find probable cause to believe that count 1 was committed and probable cause to believe that the defendant, Amy Louise Gum, is the one who did possess the controlled substance, dexamphetamine dimethylate. I'm sure I'm not saying that right, but as listed in the complaint and information filed herein. Defendant being bound over for arraignment. Missy, who will she go to and when?
Excuse me, this case goes to Judge Satterfield, and she is available February 12th at 2:30 by Zoom for arraignment.
Is there any other date she might have available?
Yes, I also have March 12th, anytime between 9 and noon or 2 and 4.
Is that like a Franklin day planner?
I've got a 3 o'clock, so I could do a 2 or a 4, whichever you prefer, on the 12th.
March 12th at 2.
2 it is.
That works for me.
Very well, this matter is continued to March 12th at 2 p.m. for arraignment via Zoom before Judge Satterfield. Defendant will need to appear with counsel by Zoom. And that will be made the bond, although I'm not sure she's made bond in this case, has she?
Nope.
Yeah, she made bond.
Oh, congratulations.
Well, I'm not seeing it. Let me look a little closer here.
I would ask that it continue.
Well, if I can find it, it'll continue, but I am just not. When does she think she made it? Before she came to court or after?
It was after the first appearance from the jail. It was August, so it would have been like August 5th, maybe whatever Monday was.
After court.
August 8th, 2025, in the amount of $5,000.
You said August 8th in the amount of 25 or 5?
$5,000.
All right, I will continue that $5,000. I presume that's a surety bond?
It is with Florio fast out bill bonding.
All right, Ms. Gum, you will be continued on that bond. Of course, if you don't come to court, you could lose that bond and end up with a warrant for your arrest. But as long as you follow the terms of that bond, including the addition that you reappear March 12th at 2 p.m., then that bond will continue. Thank you. Anything else, Mr. Wiggle, from the defense?
Always a pleasure, Judge.
Likewise. Ms. Gillette, anything further from the state?
Not at this time, Your Honor. Thank you.
Very well, then we'll be in recess. Mr. Wiggle and his client are excused. Deputy Fisher is excused unless he's subpoenaed here for one of these other hearings this afternoon.
Thank you, Judge. Have a good weekend.
Thank you, Mr. Gillette.
Have a good one, Mr. Wiggle.
All right, let's see. Next we have, I don't see another defendant attorney, but I have a list of people that should be. Maybe we're ahead of schedule. Could that be? That doesn't happen very often.
Yeah, we don't start again until 2:30.
Oh, wow.
What happened to Mr. Garrett Bijort? Did he just fail to appear?
No, that's the motion for bond forfeiture we did at 1 o'clock.
That's what we did at 1 o'clock. Okay, so next is Mays at 2:30?
Yes.
Okay. Well, Judge, we've got to bail because Josh has found us something else. While I pull this up, there's some more information that's being released about you guys. We followed that the active shooter manhunt situation in Utah and Layton, and everyone was asking, is this related to the shooting that happened at that LDS church at a funeral? Well, there's more information that's come out about that funeral. That church is a building that's used exclusively by Tongan people. So there's a huge Tongan population in the area, and so there's the whole church group that uses that building are Tongan, and there was a funeral for a gentleman who was Tongan, who was involved in a gang called TCG, Tongan Crip Gang. There's video from inside that funeral. I'm sort of looking at it right here, where you see everyone's dressed in black with blue bandanas everywhere, and the TCG uses blue as their flag color, right? And so it was a targeted shooting where in the parking lot after the funeral, and there are cops like everywhere in this funeral, all the corners of the room, there's just cops standing there. There's blue and reds going outside and everything. A Tongan Crip gang, yes, TCG, it's a thing. And anyway, so it was gang activity that happened to be in a church parking lot. It's not that like the church, the preacher, the sermon got fiery and then people started shooting. That's not how it went. It's not how it went down. From Tonga. Did I say Tongo? They're Tongan. I don't know. Now I'm questioning my own everything. All right, hold on. We're trying to find this that Josh just sent me. Give me just 1 second. Tonga, that's it. Did I say Tongo? Thank you, Lois. The Tongan Crip Gang is a Tongan American street gang that is a subgroup or set of the Crips Gang Alliance that's according to Google. Yeah, so 2 more funerals because of one. But those shooters I don't think have been captured yet. All right, let me pull this up. This was from 21 hours ago. Okay, hang on. This one starts great, so you guys have to see this. Watch. The judge has the infinity loop going on.
Okay, I'm ready whenever you're set.
We're ready, Judge.
We're going to the first defendant now. It's going to be the female.
Okay, thank you.
We've got blur the background turned on from the jail.
Step to the counter. State your full name for the judge.
Hi,
Hello.
Candace Claire McCormack,
Thank you. And can you spell your first name, please?
CANDACE,
And then your last name?
MCCORMACK.
Thank you.
It's muted now. Just a freeze warning in the corner. Are we waiting for the sound to come back, Josh? Does it come back? I'm going to check on my phone to see if I can. Hang on. Is he muted for a minute and a half? He's muted for a minute and a half. Josh wants us to watch a silent. Okay, at 2 minutes it comes back in. So give us a second. Let's see what happens here. At 2 minutes. Here we go. There it is.
Okay, the state is alleging 4 charges against you.
Oh my God.
Those charges are the following: transportation of a dangerous drug for sale, narcotic drug possession or use, dangerous drug possession or use, and the final charge is drug paraphernalia possession or use. On those charges, you have the right to remain silent, right to counsel, and right to trial. I've scheduled you for a preliminary hearing on the 20th of January at 3:00 p.m. The preliminary hearing is to determine if there's probable cause to charge you with those felonies. If probable cause is found at that hearing, then your case will bind over to the Gila County Superior Court. If there's not probable cause found, one or all of those charges will dismiss. There's a possibility that the case will go in front of a grand jury. If that is the case, then you'll be notified and also sent information to your address in Blythe regarding that you don't need to appear. Your release conditions are as follows: obey all orders of the court, do not commit any crimes, notify the court immediately if your address changes. I'm disallowing you to return to the state of California until you receive written permission. So you're not to leave the state of Arizona without permission. I'm not saying you can't do that, but you have to request permission to do so prior to leaving the state. Do not possess or consume any alcohol or drugs without a valid prescription, and do not possess any firearms. Do you understand those release conditions?
Absolutely.
Okay. I am placing a $20,000 bond hold on you. You're going to remain in custody unless you post bond. Being that you're held in custody, you have the right to a court-appointed attorney if you cannot afford to hire one. I'll be sending a financial questionnaire to you that if you wish to exercise your right for a court-appointed attorney, complete that questionnaire. And if you qualify, a court-appointed attorney will be assigned once the complaint is issued. And I'll explain the complaint process here in a moment. Okay? Being that you're held in custody on a felony charge, the prosecutor has 48 hours from the date and time of this hearing to file a formal complaint against you. If they do not file the formal complaint against you within the 48-hour time period, then you'll be released on your own recognizance without having to post bail at all. If the complaint does file, then your attorney will be made aware of your charges, your in custody status, and the bond, and be in touch with you shortly thereafter. Do you understand that?
A little bit. So I will have to remain in custody.
Correct.
Until either the court date that you're setting, or 48 hours from now.
Yes, if a complaint does not file, you'll be released after 48 hours. If a complaint does file,
it will.
Then one of two things are going to happen. You're going to have a preliminary hearing on that court date of the 20th,
or they're going to take the case in front of a grand jury prior to that. Okay, and you'll be notified if that occurs. Otherwise, you're planned to have that hearing, and that's to establish probable cause. You also can post the bond of $20,000 if you want to get out immediately. Any other questions in that?
I would have to pay all that $20,000
Well,
to get out.
it is bail bonds eligible. You can go through bail bonds if you wish, and then talk to the bail bonds agency on how to go about doing that if you wish. So it's not secured, meaning that you can go through bail bonds.
Okay.
Any other questions?
But other than that, I could also be let go in 48 hours if there was no probable cause.
So if they don't file a complaint, okay, so that's different. That's basically like a ticket for a felony. The prosecutor must file a complaint within 48 hours of this hearing. If they don't do that, then you'll be released on your own recognizance. It doesn't mean the charges are gone forever. They have up to 7 years from the date of your arrest or the statute of limitations to file those charges, but you will not be held unless they file a complaint.
There's no way that I can get released on my own recognizance.
No,
now?
not with your criminal history and prior convictions, no.
I don't have any, I have no felony charges or anything from ever. I'm not a felon.
So in Gilbert, on 11/2025, you were charged with narcotic possession and dangerous drug possession and possession of drug paraphernalia. Okay. In March of 2025, there was sale of a dangerous drug. So when you
Sorry.
So when you tell me that you weren't charged or ever arrested or convicted or any of that, we at least have charges here, and there's much, much more on here. I just am stopping there because it contradicts exactly what you're trying to convince me of.
No, I'm telling you that I've never been charged. I'm not a felon. It's what I'm trying to say.
Well, all of these are felony allegations.
Yeah, but I was never charged with them because they were wrong.
Okay, well, so you might not have been convicted, so it might be just a confusion of terminology, but you have been charged with those charges.
Okay, but I fought them down because it wasn't.
Okay, that very well may be the case, that they reduced down or fought them down or whatever, but that is what is showing you were charged with, and that is why the bond is set. They're very related charges, and it's significant to this case.
That's crazy. Okay, thank you.
Okay, that's all I got.
Crazy.
All this up.
I just don't understand. Why would they charge me with all those felonies? I don't know. She might know more than she's let in on. But plain dumb did not work. Josh is delivering one after another.
Step to the counter, state your full name for the judge. All the way.
My name's Jose Alfredo Valdovinos Jr.
Thank you, sir.
Good luck spelling that.
And
he goes off record. The reason why they're quiet here is he's checking their personal information, like addresses and all that, to make sure they are who they say they are. So Payson, Arizona. Haven't visited there before, so that's cool. Let's see. Who is this? Where are we here? Oh, this is Kansas. We're in Kansas, and this fine gentleman has made his way in from the duck blinds to avail himself to the courts, briefly. So, Greenwood County Courthouse. I like the camo in court. Jose Jr. nailed it. Yep. It's a great waiting room. At least it's quiet, and it has apparently cell reception. So, two things I like in a waiting room. We're in Kansas. This is 13th Judicial again. Just waiting for the judge to come back in. It's got shades and readers. Maybe he can see out the top of his head as well. Blends right in. I almost didn't see him there because of the camo. With the camo starting right at the height of the chair and going up. He's almost invisible from about mid-chest up. So, if he's in the duck blinds, he better hide from the game warden. It's deer season in Georgia. I think it's duck season. Oh, you're right. It's not. No, I think it's duck season in Maine. Up north. I don't know about Kansas. It's got to be late in deer season. Isn't deer season about over? I see a DMV. How would it be to be arraigned in court and fail your driving test on the same day? That's like a double whammy. Windows are too big for a DMV. There's way too much light. This is like an uplifting area. DMVs are designed to be depressing and to suck the soul out of your body. It's wabbit season. Duck season. Wabbit season. I have to take a driving test this year. Don't jinx me like that, Laura. I'm so sorry. You're going to do great. You'll do great. We're after coyotes year-round in Kansas. Kansas, one of the states where coyotes can be hunted year-round. There are some states that view them as such a menace because of the damage they do both to livestock and to deer herds that they can be hunted sort of like jackrabbits. Year-round, any weapon. Deer season is over here except for late season extended archery opportunities. Jackalope season. Never seen one. Looked for one always. Never seen a jackalope. Deer are in season here. We keep seeing does running around with all their hair mussed up.
Is that Mr. Mays at the courthouse?
It is, Your Honor. You could barely see him too, huh?
No. Is Mr. Mays here?
That's not him, Judge. I believe he may be on iPhone.
If Mr. Mays is here, he needs to start his video so I can give him credit for being here. iPhone, what's your name?
That's Mr. Mays, Your Honor.
All right, please click on the little red microphone so I know we can talk to each other during this hearing.
Give me one moment. I use the phone.
No, it's working. It's working. Hang on.
I'm
Don't click
seeing
on
and hearing
anything.
you now, fine, sir.
Don't click anymore.
Okay.
Missy, if you want to put Mr. Mays' name on there.
See how fast Missy is. 3, 4, 5, 6.
We'll now be on the record in the 13th Judicial District, the District Court of Greenwood County, Kansas. Case number GW 2025 CR 182, State of Kansas versus Alexandra. Michael Mays, William McClendon for the defendant, who also appears in person. County Attorney Jill Gillette for the state. We are set for preliminary hearing. Mr. McClendon, is your client still wishing to have his right to hearing?
He looks like
No,
Jim
Your Honor,
from The
we'd
Office.
waive pursuant to plea negotiations.
And Ms. Gillette, will the
Jim from
state
The
be
Office.
waiving preliminary hearing as well?
The state does, Your Honor.
All right, Mr. Mays, I need to check with you on a few legal points before I accept your waiver of preliminary hearing. The court is advised that both the state and the defendant wish to waive their respective rights to a preliminary hearing. Mr. Mays, you are charged with felony offenses in count 1. Possession of opiate, opium, or certain narcotics.
Subject for last winter is 6:30 additionally restricted. Does not advise of the restriction.
Deputy Hanson, thank you. I was going to say, I think you need muted. All right. So, Mr. Mays, in count 1, you're entitled to the preliminary hearing on the felony charge of unlawful possession of the controlled substance, methamphetamine and or MDMA. Also, on count 2, interference with law enforcement, a level 8 non-person felony, alleging that you unlawfully and knowingly concealed, destroyed, or materially altered evidence with the intent to prevent or hinder apprehension or prosecution of a person by rinsing a methamphetamine bong with bleach. Count 1 and 2 are the only felony counts, so you've got a couple of misdemeanors, but you're entitled to the preliminary hearing on those felonies. At a preliminary hearing, the state of Kansas has the burden of producing evidence to make it appear that each felony crime has been committed and to show probable cause that you committed those crimes. A preliminary hearing is not a trial to determine whether you're guilty or not guilty. It is a hearing to determine if there's enough evidence to require you to stand trial, or in other words, to be bound over for trial. At a preliminary hearing, you do have the right to be present with your attorney. You have the opportunity to challenge the state's evidence, to challenge the existence of probable cause for further detention, or in your case, further bail. And you have the right to subpoena witnesses, cross-examine the state's witnesses, and present evidence on your own behalf. A preliminary hearing would apprise you about the nature of the crimes charged and the sort of evidence you would be required to meet if you were to stand trial. If you waive or give up your right to a preliminary hearing, however, there will be no preliminary hearing, and you will be bound over to the district judge for further proceedings. You will be required to appear at a later date before the district judge for arraignment, at which time you will enter your plea to the felony charges as well as the remaining misdemeanors. And until that time, you will be released on your appearance bond. You will continue to be obligated to appear under the terms of that bond. Now, have you talked with your attorney about waiving your right to preliminary hearing?
Yes.
And do you need any more time to visit with your attorney before we proceed?
No.
Do you, in fact, want to waive your right to a preliminary hearing today?
Yes.
Are you voluntarily waiving this right?
No. Yes.
Okay. And put another way, has anyone made threats or promises to cause you to waive your right to preliminary hearing?
No.
And are you in good health today?
Yes.
Are you taking any medications which might impair your judgment today?
No.
Mr. McClendon, do you know of any reason why the court should not accept the defendant's waiver?
No, Your Honor.
The court finds the state of Kansas has waived its right to a preliminary hearing. The court further finds that the defendant has made a knowing waiver of his right to a preliminary hearing after consultation with counsel. Therefore, it is the order of the court that the defendant is bound over to the district judge for further proceedings. The defendant shall next appear before the court for arraignment. And Missy, when will that be?
February 5th at 9 a.m.
And that will be before which judge?
Judge Hart.
Mr. McClendon, is that date available to you?
Work for me, Judge. I would like to be heard on bond.
Very well. Well, Mr. Mays, you will be continued on your bond at this time with set for $10,000 on Florio Fast Out bail bonds that you posted October 8th at 25. You'll be continued on that bond with the added condition that you reappear before Judge Hart February 5th at 9 a.m. for arraignment. Now, the issue of bond, he's obviously not in custody, but are there some other terms you want modified, Mr. McClendon?
Yes, Your Honor. Currently, there's a no contact order in place between him and I'd call it his long-term girlfriend, or significant other at least, Paula Stevens. They've had a relationship for about 9 years, and we'd be requesting that he be allowed to have contact with her. I believe it's already been undone on her end of things.
All right.
It's just Mr.
So they've been cohabitating up until the time of this incident?
Yes, Your Honor.
The incident.
And she's his co-defendant. Is that why there was a no contact order, to the best of your knowledge?
To the best of my knowledge, Your Honor.
All right. Ms. Gillette, your response to this bond modification request?
I don't have any objection, Judge. I think we're kind of set where we're at now.
All right, I will grant Mr. McClendon's request on behalf of his client. The no contact with Paula Stevens is lifted at this time. All other conditions will remain in effect, though, Mr. Mays. You and Ms. Stevens are not to discuss this case or use any controlled substances or be around any controlled substances. Those are going to be continuing conditions of this bond. Any questions for the court or
possibly a quick
all
drug
right.
test?
Any other questions? I will have you direct to your attorney privately. At this time, Mr. Mays, you are excused from today's proceedings. Again, continued on that bond. You're released from today's hearing. And Mr. McClendon, you're released too, unless you have anyone else.
That's all I have today, Judge.
All right, thank you. And any witnesses for this case alone would be excused at this time as well.
Thank you, Judge. Have a good weekend.
Thank you. You as well.
Thank you, Judge.
Thank you.
Thank you.
Thank you. And I believe that brings us down. Do we have any other attorneys sitting here waiting? Have a few defendants, a few witnesses. How about Michael Graham? Is Michael Graham here?
Mr. Mays is too blazed to.
I'm looking for the defendant, Michael Anthony Graham, and his attorney, Favre. Are they not going to be here? I'm sorry, Missy, I didn't catch that.
Oh, it doesn't start till 3:30.
Oh, I'm ahead of things again. Okay,
But the gentleman at the courthouse, was he here for the 2:30?
I'm not sure. Would you click on that little red microphone there and tell me who you are and why you're here, sir?
Where's the clicker?
Should be a little red microphone. You may need the jailer to help you find that. No, I think you got it. Can you hear me, sir?
Yes.
Yes.
What's your name?
John Gordon.
Thomas Gordon?
John.
Oh, John.
John. Jordan.
John Jordan. JJ. Friends call me JJ, but Judge, you can call
Well,
me John.
sir, do you think you have a court date today, or are you here as a witness?
I was subpoenaed.
Do you know which case you were subpoenaed for?
Mr. Mays.
All right, then, sir, you heard what happened. Instead of making you testify, he agreed that if we went to hearing, he would have been bound over, so he is bound over. You may go, Mr. Gordon.
Thank you.
You're welcome.
There's still shooting lights, so do enjoy.
Don't forget your phone.
Don't forget your phone.
Mr. Graham and Favre at 3:30, so see you all then.
All right, Judge. Thank you. We'll bail on that. I've used this remote so much that the button has become polished. Unfortunately, it also does not work as well. It now skips multiple courts. Oh, that's not the one. This one. Let's go back to Burnett.
I thought he said a fraud or something of that nature. I'll allow it a little. We'll give you a little leeway with that.
Allow it a little. That's cool. Nice ruling.
Mr. Chafee did pay me. He paid me with work done to the building. He gave me items, building materials, so that once everything was all finalized, we could work on changing the floor plan. And also antiques that we were planning to sell after everything got done.
Are you saying he didn't pay you in cash, but he gave you services or items that you thought of equivalent value?
Correct.
Was he involved in your plans with selling the building, including finding the person to sell them to?
No.
No. Why did you have him come and testify about those things at the February contempt hearing then?
So that my ex-husband would know that I was working on getting that loan refinanced.
But why was Zachary Chafee involved in you getting the loan refinanced?
He wasn't.
Okay.
There's some confusion happening, and I'm in the confused group.
You said that the building was awarded to you previously. What exactly do you mean by that?
As part of the divorce, the building was awarded to me.
Were you ordered to have Mr. Chamberlain sign a quitclaim deed?
Yes.
And he did that?
Yes.
But you never filed it with the register and probate.
No, I did not.
So his name was still on the deed.
Yes, but I had the quitclaim deed. I don't have it any longer, but I had the quitclaim deed that was signed.
And wasn't the issue at the February contempt hearing the fact that with his name still on the quitclaim deed, he was getting in trouble for you not paying the taxes?
I don't know.
You don't remember what happened at the February 3rd hearing?
I don't remember exactly.
And wasn't one of the other issues his name being on the loan, as you did talk about the loan today, if you didn't make payments and his name's on it, he's also in trouble for that?
Yes.
So the reason why Judge Anderson at the February contempt hearing ordered the property to just, if it's not sold by March, was because Troy Chamberlain was suffering injury because his name was still on all this stuff.
Yes.
Okay. No other questions?
Ms. Landgraf? Any additional direct?
Mr. Chamberlain, did Mr. Chafee work on that building when you and Troy Chamberlain were still married?
Yes. Troy Chamberlain hired him in April of 2023 to do work on the building for us.
Okay, so he's very familiar with Zach and what he was doing with the building.
Yes.
No further questions.
Okay, Ms. Perrin?
After you were, excuse me, after you were awarded the property in the divorce, did you have any other tenants besides Mr. Chafee?
Yes.
Okay, and how many?
2.
Okay. No further questions.
Mr. Schmidt?
What parts of the buildings were these other people leasing residing in?
I'm trying to figure out.
One was the second floor space.
This looks like a civil suit.
And the other was a room in the basement.
But we've got 2 people in jail outfits, and I can't.
Were there periods of times where these other leases were going at the same time as Zachary Chafee's lease?
Yes.
Where were you residing during those times? Was there still a space that was exclusively yours?
Yes.
Where was that?
It was in one of the main floor rooms.
Okay. No other questions?
You said the main floor rooms?
Yeah.
Ms. Landgraf?
Nothing further.
Ms. Perrin?
Nothing further.
All right, thank you. She may step down.
And go back to wherever she's going back to.
Ms. Landgraf, additional witnesses?
No.
Ms. Perrin, any witnesses?
No.
Mr. Schmidt, any witnesses?
No witnesses. I would move to enter the segments of the transcript I attached to my brief as evidence. It sounds like the court's just taking judicial notice of the whole transcript, though.
I have, and I've done so already.
So I'd ask the court to do that instead then.
All right, I've taken judicial notice of the entire Polk County family matter at the last hearing, at the suppression hearing that we had, I believe. Well, I think my order was December 8th.
I don't like family
I can't
courts.
remember when our hearing exactly was. I did take judicial notice of 23 FA 112, the Polk County matter. So I will do so on the record with regards to that entire transcript. Argument, Ms. Landgraf?
Judge, given the evidence, although I don't think that it was specifically necessary that we needed to enter the lease into evidence because Wisconsin statute 704.19 periodic tenant would apply. But clearly these leases were signed way in advance of any contempt hearing. There was a plan for the building. And Mr. Chafee had a reasonable expectation of privacy, and my client was his overnight guest. And I believe that all of the evidence should be suppressed.
All of the evidence to be suppressed.
Ms. Perrin?
Just to address a couple of issues, maybe a little bit out of order. The fact that Ms. Chamberlain had other tenants goes to the credibility of her statements about this lease. The fact that there was testimony about this lease before the officer approached the house on, I believe it was March 16th, telling Mr. Chafee he had to leave, reinforces the credibility related to the lease being in place before. I would agree that a periodic tenancy would have been in place otherwise. However, there are certain factors that I just stated that go to the issue as to whether there was a lease or not. The officer, and I put this in my original brief, her decision to throw the lease on the ground and claim ignorance was not done in good faith, and that does not absolve.
He threw it on the ground.
The police of violating constitutional rights, and so again, we renew our request to suppress the evidence. Thank you.
All right, Mr. Schmidt.
We have a number of different issues within the same motion that all interestingly have different viewpoints. That is, they have different standards of review. When we talk about whether the defendants met their burden of showing there's a legitimate expectation of privacy in an area, we're taking an objective standard, we're taking a look at all the facts, we're actually determining, did this person have legitimate legal rights? You look at Seventh Circuit case law, they do get into the morass of, is the person illegally staying there? Do they have a valid lease? Things of that nature. I think the court made a decision on its order for that. All of the evidence entered today goes towards that one. The court also, in its decision and order, made rulings that suppression wasn't merited for other reasons. None of those reasons have been touched on today. To those other two issues, I direct the court. The first law enforcement contact with Karen Krupa, her coming there with Troy Chamberlain to remove Laura Chamberlain to enforce the order as she read it from Polk County, which does clearly state law enforcement must go there and help remove Laura Chamberlain. She's not to be there. No leeway to be there as an overnight guest of somebody who does take possession of the property. I don't even think Troy Chamberlain could have gave her permission to stay there with that court order. They enforce that order. They don't need to take all arguments other people give them to the otherwise. If they had chosen, I'm not going to remove Laura Chamberlain, I'm not going to remove Zachary Chafee, I'm not going to let Troy Chamberlain take possession of the building as the order says, they were running awry of the court. And Karen Krupa was correct when looking at both things to say, I've got to follow the court order. You should litigate your claims in the Polk County Court.
It's a suppression hearing.
Because Karen Krupa saw no piece of criminal evidence there, because the only way she saw any was after Troy Chamberlain was there. He called her and said, hey, we found a marijuana plant. Her observations of what she did there are completely severed from the warrant that would happen later. None of those observations went into the warrant that happened later. It's disconnected, and if the court found that there were a constitutional rights violation, that eviction is the sole grounds of removing Zachary Chafee, the remedy would not be suppression of evidence. The remedy would be a civil suit. Just the same way that if a no-knock is violated, the violation, a no-knock, sorry, I'm underwater. Just as if the constitutional prohibition against unreasonable no-knock search warrants implicit in the Fourth Amendment was violated, the remedy is not to suppress evidence. The remedy is to allow them a cause of suit. The remedy must be tied to the violation. The police were not searching for evidence. They didn't even find evidence. The police were enforcing an order. The remedy doesn't make sense. What the court would have to find to suppress evidence is it'd have to find either the warrant that they executed was so plainly deficient no reasonable officer would rely upon it, or that there should be evidence suppressed off of what Bridget Getz did, somebody who had nothing to do with removing these two individuals from the building, and that as a result of her observations being unconstitutional and then being removed from the search warrant, it no longer met probable cause. As I've said in my previous motion, I don't think that applies. I think that's what the decision order concluded to. Thank you.
Thank you.
Can I respond?
Did I ask Ms. Landgraf for argument? I went first. Oh, sorry. Yes, I will ask Ms. Landgraf if she has a response.
Ms. Perrin can go first. That's fine.
Ms. Perrin?
I just want to refer to the brief I filed on November 10th, again, citing a decision by the Supreme Court, reiterating its position that a seizure of property occurs within the meaning of Fourth Amendment whenever there's a meaningful interference with an individual's possessory interest in that property. When it comes to my client, he was not part of the Polk County order. He was not noticed in any way. He was not named on the order. So his privacy rights, it was clear that he lived there. He was giving the officer, trying to tell her that he had a lease, obviously stating that he lived there. That's what she testified to. And that gives him a privacy interest. And so his interests were interfered with. And as such, the resulting evidence that was found because of that interference with his possessory interest.
You can't talk to each other.
Should be suppressed.
Sorry, Ms. Perrin.
You can't talk to each
The
other.
defendants were talking to each other.
They still are.
So I missed the last brief
I just
statement.
said that because of the interference with his possessory interest, the evidence that happened after that should be suppressed because it all stems from that one event. And because he's not part of the Polk County order, he wasn't noticed on that. He's not part of that paperwork. His privacy interests were interfered with.
Thank you, Ms. Perrin. Ms. Landgraf?
Quick ruling.
Well, I would agree. The only reason why the officers went in there beforehand was because, or the only reason that the security guard or whoever even had access is because the police involved themselves in the first place when they shouldn't have. So I think everything stems from that, the fruit of the poisonous tree.
You took the words right out of my mouth. Fruit of the poisonous tree.
Okay, thank you. I'm not going to make a decision. I'm doing a written decision. Because quite honestly, I do think that, as Mr. Schmidt stated, I don't know how he exactly stated, but there's multiple issues that have multiple levels of review. And I believe that to be true. And I want to make sure that I review them and I reconsider my previous decision, perhaps in total. Now that I have leases and some information
Judge,
as it relates
if you're not going to make a
to
decision.
that.
Is in court represented by counsel.
Ooh,
we were last here on May 14th, where the defendant pled guilty to count 5 and count 6, both being sexual battery felonies of the 3rd degree. At that time, the court referred the defendant for a pre-sentence report and victim impact statement. Those reports have been completed, and the state is prepared to proceed with sentencing.
Mr. Watson?
We're going to bail.
Thank you, Your Honor. May it please the court.
It pleases us to bail on this one. Sorry, Minecraft. We're out. Let's see, Burnett. We could go to Simpson. Let's go back to Kansas, maybe. Let's see. Amanda Franks. It's under me. Kel Station 3's iPhone. Burnett's done. Not going to stick around for the next one. Let's see what else we have. 13th Judicial. Could jump over there again. There's a good Buffalo in this one. Here we go. Let's go to Buffalo.
And all I'm asking from you is to really organize your case. I will try not to interfere with a lot of, I will try not to interfere with a lot of questions. I tend to do that, and I can contribute to slowing things down for sure, and I know that. I'm try not to do that at all. You guys are capable counsel. You'll get to it if you don't. But if you would be as organized as possible, what's important in your case, and be considerate of time. Let's do everything within our power to have this done within that 2 days. I don't think it helps. I don't think it'll be good for anybody to go beyond that. So please keep that in mind as you're preparing your questions or you're organizing your witnesses or getting ready for trial. And the more you can stipulate to and not argue about exhibits, or if if we can find time to do a pretrial hearing because you want to go over something. I don't know how much time you have available or we have available between then, but if there's something I can clear up for you, please let me know. Otherwise, we'll see you at trial.
Let's see, Josh is, they're done. They're done. Josh is finding all sorts of stuff for us, and this is sort of punishment for not going to some of the stuff he showed us earlier. He's been giving me these every single day, and some days we follow, and some days we don't. Okay, this happened when?
She got denied, and then she started.
Let's see, when is this? What is that? Is that the link that it starts at, Josh? Like a 7-hour stream? No, it's a 49-minute stream. Okay, sorry. Wrong one. There we go. I hear you.
We're not doing that. Say it appears.
We're going to back up to the beginning. We have body cam.
For testimony, correct?
Well, argument.
Sorry. Okay.
Yeah, we have a witness.
No. Okay. All right. It's your motion, counsel, so you may proceed.
Thank you very much. So I filed a motion to dismiss suppressed evidence and because fancy, and we'd like to play the video. So I'd like to move for admission of the video of the defense exhibit A dash cam. And the crux of our...
I'm sorry, just a moment, counsel. Mr. Kuzmiak, any objection?
I know exactly what you're going to be presenting. I mean, for purposes of argument, I think you can utilize that to raise the argument at the motion, but to admit it into evidence that could later be used at trial, I don't know if that's appropriate.
Okay.
Yeah, I can present the evidence. I mean, she asked me if I had any evidence to admit it. I have videos. I don't know if if the court wants to move for admission or if you just want me to present the videos. Mr. Kuzmiak, sorry, Your Honor, I should be standing. There were videos provided to me by the prosecution. They had an opportunity. The videos that came straight from the police officer, so I'm not sure why it would be an issue to admit them in any case.
I think what I was hearing is the issue is whether or not they would be admitted as an exhibit as far as evidence goes, or is it more to support your motion?
It's to support my motion. It doesn't matter either way.
Okay. All right. Well, I'll hold that in abeyance. I'll let you continue with what you were going to.
Very good. And the reason why I bring the video, it really speaks for itself. What you'll see in the video is the police officer fails to articulate or have any justifiable reason to stop a vehicle. First, he claims that she was coming out of a parking lot, almost hit a car. That never happened. It's clear in the video. And then he says that she failed to maintain her lane. That also never happened. It's also in the video. You'll find that there was no breaking of the law. She was absolutely compliant. And then most importantly, even if we can see that there's a reason, we can find it in the light most favorable to the police officer's testimony or the police officer's what he wrote in the police report. Even then, he can't expand a traffic stop without articulable reasonable suspicion at all. And he doesn't say that there's any odors of intoxicants coming from her mouth in the vehicle. There's no evidence of slurred speech. There's just nothing. He goes straight into OWI interrogation. And that's kind of, you see, she comes out of the parking lot, and he just immediately starts following her. Major red flags all the way around. And then you can see, after stopping her, he immediately talks about whether she drank and so on. Even in the field sobriety test, Your Honor, there are no issues. She wasn't wobbling. He tries to trip her up several times.
Ghost pepper ranch is what you want.
Once where she made a mistake, she caught herself immediately and then went back and corrected herself. There are absolutely no signs of intoxication. So even if the court finds that there was a reason to stop her, he fails reasonable articulation of suspicion. There's no probable cause. All of these things are dismissible reasons, from the initial stop to the lack of reasonable suspicion to the lack of probable cause. And when we present the video, you're going to see just that.
Okay. Mr. Kuzmin?
Your Honor, Mr. Arago was presented an argument to the court. However, I don't think it's a complete argument. Mr. Arago indicates that there was no reason to pull the defendant over. However, in the police report and in testimony that would be elicited from police at trial, it's indicated that the police officers observed the defendant's driving and that the driver had almost struck a parked car with the door open. That wasn't caught on video because the video camera wasn't on. The police officer was driving in one direction, she was driving in the other direction. The police officer then had to turn his car around and follow the defendant. And that's where he noticed the defendant drive into the 7-Eleven in Middle and Chestnut area, and then followed the defendant, where he indicated again that she had difficulty in the lane, also observed a back light on the license plate not being operable. And for those purposes of the initial vision of the defendant driving, almost striking a car, to her subsequent driving, to her stop, gave what we believe is probable cause to effectuate a stop, number one. One stop, police officer made appropriate investigation of the defendant, and by the defendant's own admission, it indicated that she had been drinking, failed a simple little test of, a question of whether or not to do a 9 or 11, what is the middle number? She picked 9, and then turned and offered the various field sobriety tests. According to the police officer and police officer's testimony that would be elicited again at trial, the defendant failed those field sobriety tests. She also then refused to take the preliminary breath test, and then she was taken to the station, where she then did register in excess of the legal limit with regard to the breathalyzer and toxalyzer. Your Honor, we believe that the stop was valid. We believe that the actions of the police officer were valid. We believe it was an appropriate stop and appropriate issuance of a citation.
Okay.
Your Honor, may I briefly that?
Well, I think I can watch the videos. Any objection to me watching the videos?
Your Honor, I have no objection to watching the videos. It's basically, it wasn't an evidentiary hearing, so we weren't going to elicit this or make this a part of the record, but allow the video to be viewed for the court's determination.
Thank you very much.
Okay.
Judge, if you watch, we get to watch. This is the rule. So I might have to turn my screen off for a minute so we can see the whole thing. Put it up on the big screen for us, Judge.
So I've got to grant access to the.
You sharing your screen or what?
To screen share?
Yes.
No, it's on the bottom. It's open. It's
on the bottom?
Maximum protection on my computer. It's asking me to put in my password.
Oh, for you. Okay.
Yeah.
Okay.
So you have to, pardon me, Judge, I have to look at the bottom of my computer so I can find my password. We now know his password because we watched him type it. It's got two-factor authentication. You like bacon? 80s? Hopefully it's good for you. I trusted Thomas and said, no, I'm going to pass on that one. All right. Let's see. What am I covering up? Not much in this corner, so I'll stay down here.
Here,
Let the video speak for
prosecutor
itself.
indicates that he had to turn around somehow. That the police officer observed something and then had to turn around. This shows a police officer parked, not turned around, and clearly wasn't in pursuit at any moment in time.
Okay, let me just ask one question. Mr. Kuzniak, is this, because in your argument, you stated that the officer turned around and then waited for Ms. Palazzolo to exit the 7-Eleven parking lot. Is this before seeing Ms. Palazzolo with the car, or is this after they turned around and noticed she was in the parking lot?
Yeah, Your Honor, this was a video that started, but it was after the initial contact that the police officer had with the defendant.
Okay.
Initial contact occurred on Oak Street. The police officer was going westbound on Oak Street. Solo was going eastbound on 4th Street. That's when the police officer observed the door being opened and Ms. Palazzolo, the defendant, almost striking that car. Then Ms. Palazzolo continued eastbound on to 1st Street, made the right turn on 1st Street, and then came down and eventually ended up in the 7-Eleven. The police officer had to turn around, followed the defendant back, parked, and then observed the defendant re-enter the car and then drive away. So the biggest argument that the defense counsel raises is that, some of the issue about probable cause and why to stop. It's not on the video. And it's my understanding in talking with the police officer that the video doesn't automatically kick in because, in effect, the police officer was driving eastbound versus the car coming westbound. When he noticed it, that's when he was able to turn around and follow the defendant.
So wouldn't it make more sense if we had the testimony of the officer?
Well, you know what? We've adjourned this several times, Your Honor. We knew exactly what we're going to be doing here. He didn't prepare his witness properly. We're not going to adjourn it. I'm asking, Your Honor, not adjourn this again. And relying on Mr. Kuzmiak's testimony, it basically would be akin to hearsay testimony of a police officer.
Well, okay, so just a moment. We set this for a motion hearing, not an evidentiary hearing. So a motion hearing is a motion hearing on the legal arguments, which is not necessarily requiring any witnesses to testify. If it was set for an evidentiary hearing, then absolutely there should have been witnesses here to testify.
Sure, it may not require it, Your Honor, but he's certainly at leisure to bring witnesses to a motion hearing, as much as I'm allowed to present evidence of the same.
Well, I mean, I would presume that perhaps anybody can bring a witness to anything, but
I don't have to.
not necessarily for a motion hearing specifically. Typically, if it's set for an evidentiary hearing in this court, that's when witnesses are subpoenaed or required.
I understand that.
Okay.
But if he was going to admit or offer testimony that is not somehow in the video or corroborated by a video, I think it'd be prudent enough to bring that witness in, or at least call me up and say, this is what we need to do instead. I don't need the police officer here, so I'm not going to call it. And
this is a motion hearing on a legal argument to dismiss. There's not been a request by either party, either side, as to whether or not it should be set for an evidentiary hearing. And this court didn't order it set for an evidentiary hearing. I set it for a motion hearing.
Sure, and I don't need that. I don't need it in an evidentiary.
So Okay, well, I may need an evidentiary hearing, but we'll see.
But to allow Mr. Kuzmiak to basically testify for a police officer, I think is wrongful.
Counsel, just so you're aware, I'm listening to both of your arguments as far as each of your positions as to the stop, where the stop occurred, what precipitated the stop. Okay, and so I've already heard, absent any conversation or specific verbatim discussion between Mr. Kuzmiak and the officer, right? I'm looking to see with right here what this is, okay? So, and I'm also very much aware, which I'll take judicial notice, that it's my understanding, so I guess I really can't take judicial notice until this is confirmed, that the do the cameras flip on when the lights flip on, or is the camera on all the time?
The camera's not on all the time. It's only when the police, eventually effectuate a stop or begin the process of that. Is my understanding.
Okay, so if they're driving down the road, it's not necessarily on capturing everybody's driving.
Your Honor, first of all, that's not the case, and I'll tell you why. Because he's clearly not effectuating the stop at the time that this video starts. And if he saw something that would tend to support any evidence of probable cause for a stop, he should have activated it then. So allow some sort of testimony or even take that into account when video doesn't even corroborate that. And since it's within his control to activate the video in order to preserve evidence, if it actually exists, he should have done that at that point. So I'm asking that Your Honor just consider the video as evidence. It's uncontested, and unlike officer testimony, who's not even here, really just taking.
Well, I don't know about uncontested. I think sometimes video can be taken out of context. I don't know about uncontested.
I'm sorry. I was saying that this video actually exists, and this is the police officer, and that's the day that it happened, and this is the incident involved. That's what I'm saying. This is an uncontested video as to the fact that this is demonstrating what happened that day, or capturing what happened that day. May I please continue?
Your Honor, if I could only reply briefly, is the fact that defense counsel is fully aware of the position of the prosecutor. It's laid out in my response to his motion, with regard to his comment. He believes that the only thing that can justify a stop is what the video provides. I said that from day one, that this is within the officer's prerogative to investigate a situation which he first identified with the driving on Oak Street, which was far apart from this particular location.
Sure.
Again, as the court indicated, if defense counsel wanted an evidentiary hearing, could have asked for it. We would have provided our witnesses to that effect. We're not required to provide our witnesses, at a motion hearing that is allegedly on basically of a legal claim. And we find in our responses there to support the position of the prosecution that this was a valid stop.
Sure, and that means anybody can just fabricate a story that's not captured on video in order to justify why they didn't do a birth certificate.
So, counsel, are you suggesting to the court that if something is not on video, it did not occur?
I'm suggesting that one should practice caution when relying on that sort of information. If there are other inaccuracies that are later demonstrated through the video.
So if I went over there and did a whole set of jumping jacks that was not covered on video, and then later on somebody saw me sweating on video, is that right there conclusive as to what happened?
You could have been playing basketball instead of doing jumping jacks.
Well, right, correct. So my point is that just because it's not captured on video with exactly what happened doesn't mean that an individual's direct observation is minimized. That's my point. So it appears as though we need the officer to testify.
Well,
because I don't see how I'm going to be able to make any sort of ruling on a legal argument without having some factual testimony from the officer at issue before I can make my ruling on whether or not there was probable cause for the stop.
Well, Your Honor, and I would just ask that that's not necessary because the video shows a certain thing. And in addition to that, even if the stop is totally fine, everything after that is not. So we really don't need the police officer's testimony. The video speaks for itself. I believe that you'll find that there is enough basis to dismiss this, even if there wasn't a reason for a traffic stop.
Okay, so are you stipulating that there was a reason for the traffic stop?
All the actions in the
I'm
top
saying
right
there's
hand corner.
not only no
Sorry.
reason for the traffic stop, but even if the court finds that there was no reason to expand it into an investigation for operating while intoxicated because there's no reasonable articulation, because after the stop has occurred, we can see that the video's already started. So it doesn't really matter what the police officer said.
But this is not the stop, because your client's still at 7-Eleven.
I understand, but we have to start with the stop first, Your Honor. We have to start where we start, and then we'll go into the body cam footage. And that'll we don't need an evidentiary hearing. We've done this a ton of time. We know what the police officer is going to say. It's exactly what's in the police.
No, we don't know what the police officer is going to say, counsel. I don't make any presumptions nor assumptions as to what any testimony is going to be. I don't have the video or the ability to view video that's not presented to the court. So both counsel has been able to view this video umpteen number of times, all the videos that there are. So you may be able to presume what is going to be testified to. I cannot. So we don't know what's going to be testified to, but proceed with the video. At this point, I'm going to determine whether or not I'm going to need the testimony of the officer before I can make a ruling on your legal argument.
Thank you.
So when you press play and you press pause, please make sure you are identifying the time on the video for the record. Please.
Thank you.
Press play, please.
So here we observe.
Can we just watch the video without your narration?
Police officers parked, not in pursuit, and not moving. He's simply, you could call it spying. Until
he's lurking. Until boom.
Immediately when she makes a turn, she's using her turn signal. This is at 10 seconds in. And she makes a full and complete stop at the light. She's got her turn signal on. No evidence of anything. His lights are not activated yet.
They'll be activated at 50 seconds. We've got 10 more
She
seconds.
indicates that she failed to maintain her lane. As you can see, Your Honor, she's right in between both lanes. There's not a single issue. She's not weaving in and out. This is at 22 seconds in. Again, doesn't have any issues maintaining her lane.
And now lights are
And
active.
then about 30 seconds in. So basically
Exactly
the minute
30 seconds.
Less than a minute from her leaving the parking lot, he pulls her over. Again, she activates her turn signal at 33 seconds in. Nice and smooth, not swerving around, no issues at all. Makes a nice smooth turn, 44 seconds in. And completes a stop. Doesn't, 53 seconds in, doesn't try to flee, elude, no issues. She immediately is coherent enough where a police officer activates his lights, she pulls over, full stop at the red light, using a turn signal both times.
What's the reasonable articulable suspicion for the stop? That's the question.
That's all I'm going to play from this one, so I can activate the body cam footage.
Well, no. If you want me to review to view this, I mean, I need to see this in its entirety.
The
No,
whole thing.
Not the dash cam, because you're not going to be able to hear much. The body cam is the most important. Once he gets out of his vehicle, there's not much to see. But I'll play the next minute, and you can make that determination.
correct. Thank you.
Absolutely.
Good evening, ma'am. How are you doing? Do you know why I stopped you
Because I'm
here?
presuming at some point your client's going to be stepping out of
Back
the car.
there, you were
correct?
swerving all over the place.
There's
You
a
ran a red light,
conversation that
didn't
takes place, and
signal.
that's why I wanted to play the body cam footage.
I understand that, but at some point the dash cam is going to capture your client stepping out of the car.
Very briefly, because
Okay, and that's what I want to see.
Absolutely, Your Honor.
Judge says roll tape and shut up. Got anything to drink tonight, ma'am? License registration? Yes, you have to provide your license and registration when I ask. It's a legal stop. I'm not sure if it is a legal stop. Little conversation. Documents handed over. There's the license. No, ma'am, this...
Do we know, is that music coming from the...
That's from the police officer's
Okay.
car. Vehicle.
Luckily, Zoom edits out the music. Otherwise, we get a copyright strike right now. Zoom can detect the music as backup has arrived. Detects the background audio. Backup has arrived.
Taylor drove off the freeway into a ditch. MSC was notified. Some units available.
Drove off the freeway into a ditch. Backup's like, that sounds more interesting. Do you want to go over to that one? I can head over to the ditch one if... No, I'll stay here. What kind of flowers are those that are in bloom? They're under the carport. Do you think they're real? Must have been a slow night. Judge is regretting her asking to see everything that happened. Oh, steps out of the vehicle. Does a little hike up the... what do you call it? Is that a tube? It looks like a tube top. But it also might be the bottom.
You can see that she neither wobbles or stumbles.
Sorry, what time did you pause that, Council?
Absolutely, 3:37.
Okay.
I was just indicating as she exits the vehicle, you don't see her, wobbling, falling over, failing to maintain the balance.
I know, Council, I can observe. Please.
Please stop narrating this. And we're going to have you do a couple tests, right? Any reason why you wouldn't be able to complete these tests? All right. We're going to step right over here. Out of view from the...
Okay, you can pause this because it appears now she's mainly out of camera view.
Yep, and that's at 3:57. We stopped the video of the dash cam footage. May I proceed to play the body cam footage?
Please.
Yes.
Thank you, Your Honor.
As to which officer? It appears as though there are three.
Yep, so this is the officer that approaches her driver's side.
Right, what's the name of which officer?
Officer Salzman.
Okay.
This happened late last summer. Mid-September, there's the traffic stop. Well, he pulls out. He's driving. So we got the 30 seconds here. We're going to see the lights on in 8, 7, 6, 5, 4, 3, 2, 1, 0. He's just got the red and blues up. See him off the trees. She's signaling left. She's turning into the parking lot right here. Slow turn. He follows. Left-hand turn. She goes around the little drive-through entry thing, comes to a complete stop. He immediately throws it into park. Right behind her, jumps out and says, "Show me your hand!" No, he doesn't do that. It's not one of those stops. Let's listen to the audio. 3, 2, 1. Flashlight.
Hello. What's going on?
I'm going to my house.
You're going to your house?
Yes.
The reason I stopped you, so when you were on Oak, you were coming down, that person had their car door open, you almost hit their car door.
I did?
Yes. And then you turned northbound onto First, and obviously you went
to 7-Eleven. I just left 7-Eleven.
You went pretty quick down Cedar.
Sorry.
Chestnut, correction.
I'm so sorry.
And then your license plate lights are on.
My what?
Your license plate lights.
They're not on?
They're not working at all, so they're probably burnt out.
I didn't know that. He is getting my...
BS.
You want it?
Yes.
You should ask for it, yes. Yes.
Yeah, when you turned out of Chestnut, you pull onto Biddle.
Yeah.
And you crossed over that lane line. So you're driving into 2 lanes for a second.
So, Your Honor, we don't see that happen at any point in time. There's no crossing over any lane that happened in the video. I'm just making that clear.
It's not on camera.
That's your observation.
Exactly.
I need to watch it a little bit more closely, rather than from the quick bit that I saw it. So that's your perspective and that's your argument.
It is
clearly.
Thank you.
Okay.
Sorry.
Where are you guys coming from, Tiana?
So we literally just left my friend's house on Eureka and Orange.
Okay.
Sorry.
And where are you headed to now?
Home on Emmons and Bill, basically. Emmons and First, I guess you could say, but I say I'm in the middle.
Okay. Do you have an idea, you, sir?
So, Your Honor, just by way of making a record, she's able to recite exactly where she lives. There's no slurring of her speech. It is absolutely coherent.
Okay, again, that's your opinion, counsel.
And I'm allowed to make a record, Your Honor.
I'm not saying that you can't.
You can't make a record of my opinion.
Yes, please.
Her name is gonna be.
Thank you. Gianna, how's your record?
My record is actually swell.
Have you ever had any tickets or anything?
About 6 years ago.
Okay.
I don't know why.
What was it for?
Speeding.
Speeding?
That sounds terrible, but speeding, yes.
Gianna, how much did we get to drink tonight?
Not a lot.
Not a lot?
Nope.
So how much is that?
Couple beers, not a
beers.
lot. To me, that's not a lot.
Okay. On a scale of 1 to 10, 10 being the most drunk you've ever been.
The most drink I've ever been is 10. The most drink, like, to me right now is about a 3.
About a 3?
Yep.
Okay. Can you give me a number between 9 and 11?
9.
Okay. Just go over. Can you do me a favor and hop on the car?
This was in the prosecutor's opening argument. To try to bolster his position by saying
9 and
she
11.
couldn't give a number between 9 and 11, like 10 was the only answer. 9 is between 9 and 11. It's like asking somebody a number from 50 to 60, and they're allowed to say 50. It's within that range.
Between, not that number, between.
If you would have said in the middle, I think it would be.
The question said, the question, please rewind it.
Roll tape. Can you give me a number between 9 and 11?
Like, to me right now is about a 3.
About a 3?
Yep.
Okay. Can you give me a number between 9 and 11?
Between.
9.
Between 9 and 11 is not 9, not 11. Between 9 and 11 is 10.
It sounds to me like a range rather than what's in the middle.
Counsel, my interpretation of between 9 and 11 is 10.
10. 10, sir. It's 10.
Okay. Please press play.
So she's bad at math.
Can you do me a favor and hop on the car?
Yeah, of course. Gladly.
You got no weapons on you?
Nothing.
Well, I'll have you walk right back here, okay? I'm gonna shut my front lights off. Just hang on right there.
Okay, we're going to throw the IDs there in the car. We'll deal with those later. All right.
Would you be willing to do some Santa Fe sobrieties to make sure you're okay to drive? Cool. I'm gonna have you walk right over here, okay?
Your Honor, if I just made a note for the record at this point in time.
What time did you pause?
That was at 3 minutes and 48 seconds.
Okay.
I'm sorry about that, Your Honor.
That's okay.
She had just given birth 3 months ago. Not sure how much that tends to play in somebody's behavior or anything like that, but just wanted to know for the record though there was.
I've had 3 children. I don't know how that would relate into that or not.
I don't know. I've never given birth before. I was,
He's like, I haven't had any. I've never given birth. In a church?
Do you have no medical issues with your eyes? No traumatic brain injuries, nothing like that?
No.
Perfect. Awesome. Keep your arms out by your side. You're gonna follow the tip of my finger with your eyes and your eyes only, okay? Try not to move your head at all.
Nope, failed.
Just know for the record that starts at 4:05 in the video.
Okay, sorry.
That's one. Okay, she did okay there. I can't see the jitter. There appears to be some jitter. I'd say there's another fail there. Okay, probably fail on the eyes. She's jumping ahead, anticipating. So I count 2. There may be more. And hold. There's the jitter there. There's 3. Difficulty holding the extreme angle. Yep.
I only had a little, sorry.
Keep watching.
Now we just see his arm. Okay, she has not lost balance.
All right, this next one we're gonna do, you see,
And so that, we started at 4:05 with that test, and that ended at 5:25, so that was about a minute and a half. So it's a bit unusually long for that sort of test. You could see he's not convinced, he's got some pursuit.
Well, counsel, you cannot make an argument as to whether or not somebody is convinced or not. You don't have the officer here to testify as to whether he was convinced or not.
No, but
that is your summary and opinion based upon watching this.
No, of course, I'm not.
But you cannot
Just
tell the
entering it for the
court what
record.
somebody's thinking or feeling, unless this officer says it right on the record.
Sure.
Or right on the video.
So Mr. Kuzmiak is not allowed to say what the officer said or felt, right? Also,
Counsel, right now I'm talking about this right here and your statement that he's obviously not convinced.
okay.
Okay? So if there's another statement by Mr. Kuzmiak, we'll address it at that time.
Well, then I would just state clearly, after reviewing hundreds of videos over 10 years, this is an unusually long test. That's my argument.
Okay.
you see this line right here?
Yes.
Would you agree that that line is pretty straight, as level?
Read.
Good. So this one, we're gonna do a walking test, okay? If you would like to take your shoes off, I don't see any debris, or you can keep your shoes on, okay? Cool. So this one, you're gonna put your left foot on the line.
Left foot.
Yeah, left foot on the line, right foot right in front of it. Put your
And.
hands on your side, yep. So left foot on the line, right foot in front of your left foot.
Ready?
Put your right foot in front of your left foot.
Right.
There's 4.
So when I tell you again, you're gonna take 9 heel-to-toe steps forward. Okay, when you reach 9, you're gonna plant your lead foot. Using your rear foot, you're gonna take a series of small steps to turn around.
I can't
9
follow
steps
this
back.
one.
Okay, let me
I fail this
demonstrate
every
it for
time.
you.
Forward.
I'll demonstrate it for you, okay? 1, 2, 3. So on to how many steps?
3.
How many are you gonna take?
9.
9.
You're gonna take 9, correct. You're gonna plant your lead foot. Using your rear foot, you're gonna take a series of small steps to turn around. 1, 2, 3. So on to how many? 9, perfect.
First.
Nope, you're gonna do 9 the entire time, okay?
But you did 3, okay?
Yes, just to demonstrate it for you, I did 3, okay? The entire time you do this, keep your arms out by your side.
Okay.
You're gonna stare at your feet, you're gonna count each step out loud, and do not stop until you feel you have completed. Do you understand all these instructions?
No one
Yes,
can
I
pass
You may
this.
begin.
1.
Face your stare at your
Hands,
feet.
hands by your side.
3.
Face your stare at your feet, okay?
4. 5.
You're not looking at your feet.
6.
Your Honor, this is at 7:01. I would indicate that in the directions that he initially gave her, he never told her to stare at her feet.
Yes, she did.
He
You
only
did.
gives her that
You did,
direction
you
after
did.
she begins to trip her up.
No. No, go back.
Go back. It's
Because
there.
at the beginning, he says, look down at your feet. Just go back to when he starts it.
Okay.
1.
Face your stare at your feet. I'm gonna do 9 the entire time.
I'm gonna go back to where he's giving directions, Your Honor. I'll do
No, just go back to, it's at 6:35, go back to 6:25.
Okay. Can I start at 6:16 instead?
That's fine.
Thanks.
3. So on to how many steps?
3.
How many are you gonna take?
9.
You're gonna take 9, correct.
She
You're
gets
gonna plant your
numbers
lead
right.
foot. Using your rear foot, you're gonna take a series of small steps to turn around. 1,
Start.
2, 3. So on to how many? 9, perfect.
First.
Nope, you're gonna do 9 the entire time, okay?
But you did 3, okay?
Yes, just to demonstrate it for you, I did 3, okay? The entire time you do this, keep your arms out by your side.
Okay.
You're gonna stare at your feet, you're gonna count each step out loud, and do not stop until you feel you have completed. Do you
You're
understand
gonna
all these
stare at your
instructions?
feet.
Yes, I
Fine, you may begin.
So hit pause.
Your Honor, I do stand
So,
that he said that right before she.
yes,
I
okay.
do stand, I'm sorry. But I would just note that for the whole minute that he was demonstrating it, he didn't mention anything about staring at the feet until the last second before she began, but he did mention it to her.
Yes, he sure did. Okay.
Starting the video again at 6:50.
1.
Face your stare at your feet.
2. 3.
Face your stare at your feet, okay?
4. 5.
You're not looking at your feet.
6.
Make sure you're looking at your feet, okay?
9. 5. 6. 7. Sorry, fuck up there. Are you ready? 1,
Okay, now she's butchered this
2,
one.
3, 4.
She's balanced, hands not at the side. She messed up her count. She wasn't staring at her feet.
7, 8.
On this test alone, she could have been.
This next one we're gonna do, this one I'm gonna demonstrate it, and then I'm gonna ask you to follow, okay?
Yes.
So you just go ahead and face me. Keep your arms on by your side for now. Okay, this one we're gonna raise your right foot or your left foot, whichever one you prefer to raise, okay?
You said right foot over left foot, but.
Right foot or your left foot.
Or, okay.
Yep, whichever one is more comfortable for you, okay? You're gonna raise your foot about 6 inches off the ground. You're gonna point your toe forward. You're gonna stare at your foot and you're gonna count 1001,
This officer doesn't know what 6 inches.
1003, so on until I tell you to stop. Yep, so 1001,
How far do you want to go?
until I tell you to stop. Okay, it's about 30 seconds.
Okay.
So the entire time you do is keep
So
your arms out by your
basically
side.
30.
Yeah. So keep your arms out by your side. You're gonna stare at your foot. Make sure you count out loud. And then do not stop until I tell you to, okay? Do you understand all of these instructions?
Yes.
All right,
She
you
tried
may
to
begin.
start early. That's a fail.
1001, 1002, 1003, 1004, 1005, 2006, 2007, 2008, 2009, 2010, 2011, 2012, 2013, 2014, 2015, 2016, 2017, 2018, 2019, 2020, 2021, 2022, 2023, 2024, 2025, 2026,
Keep going.
2027, 2028.
All right, you can stop. So the state admission requires that you must submit to a preliminary breath analysis upon the request of a peace officer. Failure to do so can result in civil infraction and a penalty of up to $100. Will you take a PBT?
No.
You will not? Okay, it does not mean you're not going to go to jail, okay? So a lot of,
I don't,
so you're not going to take a PBT?
like a rough advisor, you're saying?
Yes.
Yeah, I won't take one.
Okay,
I know, I don't have to.
okay. So it does not mean you're not going to, you can still get arrested.
That's,
Okay, you're going to be under arrest for operating while intoxicated, okay?
I'm.
Well, when she gets arrested, they're going to draw her blood, and they're going to.
Well, if I were to say, yeah, like, what would happen?
If you were to say yes, and you're under that legal limit, or even if you're a little bit over, I'm very lenient with you, okay? If you're a little bit over, then we'll figure out, right? We'll figure out a way.
Like, cause I said, no, I don't get that, like, right, or like. Cause you said you
Well, I
were
don't know
like
if you're intoxicated, you
lenient.
know what I'm saying?
Yeah.
So, Your Honor, at 10:08, he goes, "We don't know if you're intoxicated or not," which seems to suggest he had no probable cause at all. And we see in the video, she barely messes up. She didn't have any balance issues. She never slurred her words. In fact, there were a few times he tried to trip her up, and she actually corrected herself and corrected him.
What?
For instance, he said, "I just took 3 steps. How many are you going to take?" Thinking that she might be saying 3 and didn't listen to the direction.
Again, you cannot, counsel, please stand up when you're addressing the court.
Sorry.
You cannot tell the court why the officer stated what he stated. Okay, I heard the officer say, I took 3. How many are you going to take? She said 9.
Yeah.
Whether it was to trip her up, whether it's to confirm she knew the answer or the what her instructions were, we don't know. So that we're not doing that.
Well, I can make an argument, Your Honor, and I've got great discretion on the arguments that I can make.
Counsel, you have great discretion on the arguments you can make, absolutely. But I'm not going to have you tell me why the officer said to her 9, whether it's to trip her up or not.
Okay.
Okay, we're not doing that.
Would that say it appears that one could interpret it in such a way that the officer may have tried to see if she would get tripped up in the moment, and she proved in that moment, if that was the case, that was it.
Okay, and then when she was doing the test the first time, she got to 9, and then she started back over at 5. I watched that.
Mm-hmm.
I don't think that's what happened, Your Honor.
Okay, let's rewind it.
Rewind it.
It's 100% what happened,
You're
counsel.
talking about the heel to toe test?
Yep.
Okay. I think that was 6. We'll start at 6:41. It looks like she hasn't started.
No, she started.
Sorry?
Go ahead.
For your feet, you're going to count each step out loud, and do not stop until you feel you have completed. Do you understand all these instructions?
Yes, I do.
You may begin.
Count with me.
So initially, Your Honor, he said, don't stop until 9 and then turn around. And then he tells her, don't stop until you feel you have ended. Now, that's contradictory direction. First he says, do 9 and then make your way back. Then he tells her, don't stop until.
Rewind that again, counsel.
Thank you.
Do 9 the entire time, okay?
But you did 3, okay?
Yes, just to demonstrate it for you, I did 3, okay? The entire time you do this, keep your arms out by your side.
Okay.
You're gonna stare at your feet, you're gonna count each step out loud, and do not stop until you feel you have completed. Do you understand all these instructions?
Pause,
You may
pause, please. Okay. What I heard is that the instructions were given.
Yes.
Multiple times that your client goes to 9.
Yes.
Then he says, stop when you feel you've completed. Completed
The 9
per
steps.
the instructions.
He didn't say per the instructions.
Counsel, that's the way this court's interpreting it. Okay? Because he was very clear. 9 and 9. 9, some small little steps to turn around and do another 9.
Would it have hurt for him to reiterate again that it's 9 instead of whatever she feels?
He said 9 a lot of times, but let's please press play again.
Whatever she feels does not mean 9. Can we agree on that?
No.
No.
It says when you feel you've completed. Rewind it one more time.
Okay.
The entire time you do this, keep your arms out by your side.
Okay.
You're gonna stare at your feet, you're gonna count each step out loud, and do not stop until you feel you have completed.
So you feel you've completed with the instructions, completed the test per the instructions.
I think that could mislead a reason.
That may be your thing. That is absolutely what you can
argue
think,
that to the
counsel.
jury.
That is not how this court interprets that, but you may press play.
Very good.
Do you understand all these instructions?
Yes, I do.
You may begin.
1,
Make sure you stare at your feet.
2, 3,
Make sure you stare at your feet, okay?
4,
5,
5,
You're not looking at your feet.
6,
7,
Make sure you're looking at your feet, okay?
9, 5, 6, 7.
No. Pause, please. Not only did she start back over after she hit 9, she completely missed number 8 in her counting as well when she was doing that. So,
And I would argue that, I'm sorry, I didn't mean to cut you off if you're mid-thought.
no, go ahead, counsel.
I would just put forth that,
Again, please stand up when you're addressing.
I'm so sorry, Your Honor. I would just put on the record that reasonable person pulled over. It's reasonable to be under high stress, high anxiety, trying to perform these tests to the T. There was no issue in the nystagmus test.
Well, I don't know if there's an issue or not. I mean, I don't have anybody here to testify as to that. You want the court to view the video that this court just viewed and find that there's not probable cause to arrest your client for operating while under the influence
Well,
or intoxicated, correct?
Failure for SFSTs alone, Your Honor, is not enough. And numerous courts have ruled that there needs to be slurring, there needs to be odor. And at the end, he goes, we don't know. So now that he didn't articulate on the record, you knew that his body cam was on. There's zero articulation that he thinks that she's drunk. He even says it himself. We don't need the officer's testimony. He goes, we don't know.
Counsel?
Yes, Your Honor.
I 100% disagree that we do not need the officer's testimony because that may be taken out of context. I don't know. I can tell you what I observe right here. There's something that's going on and that's not somebody that's 100% sober. I 100% can tell you that. That is what this court sees at this particular moment. Watching the SFST with the heel to toe test and listening to the interaction between your client and the officer while your client was still in the car. That is what I can tell at this point. So I do think that the officer's testimony is necessary for this court to make a complete ruling because whether the officer stated, well, we don't know if you're intoxicated or not, that was in response to the question of your client about
refusing.
So I don't get that consideration if I didn't take the PBT.
Yeah, he says, we don't know. So that means he doesn't have probable cause to believe that the crime of operating while intoxicated has been committed, which literally destroys probable cause. Even if he came in here and contradicted that, it doesn't matter. He can say whatever he wants on the record. the video shows itself at the time of the offense, which is what we evaluate, not afterwards, but at the time, whether there was probable cause, and there clearly is not. Because he,
Well, no, that's not clearly is absolutely not accurate, Colin.
well, he clearly.
Because what I'm seeing,
Yes.
what I'm seeing is that there's probable cause for your client to have been arrested for operating while intoxicated.
I see. But the issue here is we don't hear any slurred words. She doesn't trip over her words. She gets all her words clearly. She can articulate where she lives. She didn't have any balance issues. Even when she tripped up, she corrected herself, especially on the 1027 it was. She corrected herself. This is not a person that shows signs of intoxication. It shows high competence in a high stress situation.
Or counsel, perhaps it could show somebody that consumes a lot of alcohol and can contain themselves. I don't know. So then we're going to have the officer present. We're going to set this for an evidentiary hearing so we can hear from the officer.
I mean, let me ask you a question, Your Honor. If the officer comes here and testifies and says exactly, well, I believe, she was intoxicated, but stuff in the video. I mean, are we just delaying the inevitable that we're gonna
Counsel, I am not, listen, if I could do all that, I could tell you what the winning lottery numbers were. I want to hear what the testimony is from the officer, and then I will make my ruling. Let's set this for an evidentiary hearing on, what does January 21st look like for us, or 28th? Ellie?
28th, we're busy. I can't do it.
What week is your jury trial, counsel?
Week of the 26th.
It's easier to keep something out of court than try to
No,
fight it in court.
Okay, so we can potentially do the 21st.
I'm sorry, I can't do the 21st either, Your Honor. I'm just doing it that day.
The 4th, February 4th.
The 4th is good for me, Your Honor.
Does that work for the people?
Your Honor, it works for the people. I just need to confirm with the officers that he's available.
Okay, does that work for us, Ellie?
As long as it's in the late morning.
Okay, 11 a.m.
Let's do 11:30.
Okay, 11:30 a.m.
Josh, you still got your calendar?
Mr. Kuzmiak, the officer is not available. If you could please communicate with the officer today and then send an email, including the court and Mr. Arabo on the availability one way or the other so that we're all on the same page. Okay? All right, bond and conditions are continued. Thank you very much.
Thank you so much, Your Honor.
Thank you. And then we have one other, we have to call this one.
Anything for us?
No, you're all set. Bond and conditions are continued. Thank you. You as well. We're on the record in the matter of the City of Wyandotte versus Dane Jones, 251657. Appearance for the people, please.
Yes, Your Honor. Pat Viscusi, I appear on behalf of the people of the city of Wyandotte.
Thank you. And counsel?
We're gonna cut from that. It's time. It's almost 5:00. Wow. The attorney fought hard, but was not successful. Did not win that one. Josh had clocked out. Time to go home. Josh, did you got that on the calendar though? Josh, please tell me you got that on the calendar. One more thing to watch for. That would be a spicy one with the possibility of the officer. First, here, let me tell you what I think will happen. Having been through police academy on the citizen side, been able to be trained on how these roadside sobriety tests or field sobriety tests are function and what they look for. My initial time I watched a roadside sobriety test with someone I knew I had watched consume alcohol for a period of time. My initial thought was, oh my goodness, she totally aced those tests. What a rock star. I don't drink, so I don't know how much, but she had a lot of these things and did none of this thing, and I thought she's able to hold it. She could pass, she could drive drunk and get away with it. And then the officer listed all the places where she failed in the test and asked us how many we caught. And I had caught none, 0. But then they started to show what they look for on the eye test and the jitter in the eyes and the balance where the hands come away from the side and everything. And we did another test. I'm like, oh my goodness, she is sloshed. She is. Somebody better catch her in case she falls. And it wasn't that she suddenly became stumbling drunk. It was just that some of the indicators on the test are very subtle. And I also know that I cannot complete one of those tests. I would have said 9 as well. And you guys have seen me. I've had nothing to drink all day. I haven't had nothing to drink for the last 20 years. But I would still fail that test, and I would fail the balance one and the holding my foot up and counting out loud. I suck at these tests. I don't know why. But I mean, it's terrible. I would fail as well. So, but I would tell you one thing. I'd be happy to take the breathalyzer. So, I can blow zeros all day long. All right. How does the jitter play with astigmatism? Okay. I don't know I think if you have a medical condition with the eyes, you can let them know that you have that. But they are looking for jerky movements of the eyes. They're looking for the ability to involuntarily turn your head to try to make it easier to see, especially on the edge of your vision right there in that peripheral range. They'll look at your eye dilation as well, and the response time as they're shining lights in your face while you do this. Lots of things they're looking for. So, a big one that people fail at is starting before the officer says go. They're like, okay, I've got this, and their foot's out, they're up in the air, and everything. And it's like he at the very beginning he said, wait until I tell you to begin. But when you begin, you'll be doing this, and their hands up, and they're the 3 before anything happens. I would ace the backwards ABC test. I cannot do that one. Play the music. It's been a rough week. All right, Laura, we will do that. It is time to go. It's time to go. Enough work for the week. Thank you, mods. Red pens. ZYXWVUTSRQPONMLKJIHGFEDCBA. There we go. Tonight when you go home, please hug the people you love. Smile at someone, make their day just a little bit better. And please stay safe till we go live again Monday morning. It's going to be Monday or Tuesday where we'll be picking up a new case, and we'll be sticking with it. And if they don't, honestly, if the new cases get pushed out like the Sarah Grace thing did, we're going to have to go to Uvalde and catch up. I just don't know. We need a trial. The bills don't pay themselves. So you guys be good to each other. Thank you very much for your support. Love all of you. Be kind. Have a great weekend. Do something fun. Take pictures. Send them to the burner phone. Appropriate only. I shouldn't have to say that. You guys know the rules. Have a great weekend for sure. If you want to catch up on something, look for the ice fishing trial on our replays. That's a little spice that'll get you through the weekend as well. So yes, Regina said the quiet part out loud. You guys have a good weekend. Bye-bye.